into areas relating to estate management, adoption, and the contentious marriage bill. We'll be hearing this morning and getting various insights from very seasoned practitioners who have continued to shape our family law landscape. And then we'll then have presentations from each and a Q&A session thereafter. And we'll then end with a panel discussion on the marriage bill. However, before we get cracking, online we do have the Vice President of the Uganda Law Society, Mr. Anthony. I'd like to invite him to give us our opening remarks before we delve into the discussion. Thank you.
Families are structured and protected and defines the obligations we owe to one another through marriage, parenthood, and inheritance. As our social fabric evolves, so too must the laws and practices that uphold it. We're especially privileged to have insights today from both the High Court and Administrator General's Office on Administration of Estates. These perspectives will illuminate how judicial practice and administrative processes can be better aligned to ensure timely, equitable outcomes for beneficiaries and families in transition. Can I proceed?
Yes, please proceed.
We will also explore best practices in adoption, addressing not only legal compliance, but also the ethical dimensions and human impact of every adoption process. The goal is to center the child's welfare while respecting the rights of all parties involved. Finally, we do look forward to a robust panel discussion on the Marriage Bill 2024, a proposed law that you're all aware has sparked significant debate and interest across board. As family law practitioners and advocates, it is incumbent upon us to understand the bill's key provisions, assess the potential impact, and engage critically in shaping the future. Let this day be more than just, ticking a box for the exercise of CLE credits. Let it be a day of reflection, shared learning, and renewed commitment to justice and equity within our families and communities. I thank the Uganda Law Society Secretariat, our partners, our facilitators, and all attendees for making this session possible. May today's discussion equip you with fresh perspectives, practical tools, and deeper appreciation for the dynamic field of family law practice. With those few remarks, I declare this CLE training officially open. Thank you very much, and I wish you fruitful deliberations. And I'm hoping this would be an engaging and learning session where we all learn from each other. Thank you very much. Over to you.
Thank you so much, Mr. Vice President, for those remarks. Just like you've introduced our topic today, this promises to be a very thought-provoking and insightful discussion. So we're looking forward to the insight from our panelists. So I'd like to get this cracking and get started. Our first presenter, who will be online, is ready to start. But I'd like to give him a brief introduction before he takes the platform. We'll be hearing from our first panelist, who, like he was introduced, is not just a lawyer, but is Assistant Administrator General and also the Head of Litigation at the Administrator General's Office. He has been practicing for over 14 years and worked at the Administrator General's Office for over 14 years. And he has helped so many estates, I'm sure most lawyers can attest to that, navigate the legal maze of estate administration. He has also been at the forefront of implementation of the recent succession reforms. And when estates hang in balance, it's professionals like Mr. Henry Kuloba who have come in to provide clarity and justice in those situations. Besides working at the AG's office, he's also shaping young legal minds as an assistant lecturer at the Uganda Law Development Center, teaching family law and land transactions. His academic journey spans from Mackay University to the University of Salford in the UK, definitely giving him both local and global perspectives on the issues we're going to discuss today. So today he'll be speaking to us on the administration of estates, procedures, and developments in succession law, a timely topic for lawyers, estate managers, judicial officers alike, as this is not just a theory, but something we definitely need in our courtrooms, in our chambers, while advising most of our clients. So allow me to welcome to the platform, Mr. Henry Kuloba Wesaka.
Thank you very much, the host. I take this opportunity to thank Uganda Society for organizing this conference, and I'm going to talk about this topic from the perspective of the Administrator General's Office. And I wanted to just say that first of all, the succession practice is very wide-ranging, and at times, of course, we get restricted to management of estates of deceased persons. Hello? Am I being heard, Mr. Host?
Please carry on.
We at times it is very easy or tempting to restrict the issue of estate planning to estate of deceased persons, but I think we might have to have a broader view and include very important aspects in succession practice, such as probate sealing, which is becoming very common actually, where, for example, a Ugandan dies, he or she was in the UK, owned the property in the UK, and also owned the property in Kampala, and they have letters of administration issued by the London court, and they want to administer the estate both in London and the UK, and probate sealing comes in. And the people who practice in this area will know that actually that is a very actively emerging area. Then we also have estates of persons with mental illness, which is becoming a very common practice area. And in my view, as members of the Law Society and practitioners in this area, we must pay attention to. Thirdly, is management of estates of missing persons. It is also a very common issue that people now, when they go missing, issues of how to manage their properties becomes key. So I wanted, before starting, to just make a sneak peek about those areas before coming to now talk about the topic, the main topic. So the Office of Administrator General, of course, where I work, and I wanted Mr. Host to just say that the Administrator General was the acting Administrator General had planned to participate in this conference, but got an emergency meeting, and therefore asked me to stand in. So the Office of Administrator General, of course, has the mandate of administering the estate of deceased person. It is both a constitutional and a statutory mandate. And administration of estates of deceased persons, we can either administer the estates, some of the estates, as an office, or vet intending applicants for a certificate of no objection, which leads to issuance of letters of administration. So if we don't administer an estate ourselves, we then issue a certificate of no objection to intending applicants after a vetting process. We also play a public trustee role, especially when you are dealing with estates of minors or estates involving minors. And we believe that maybe our role as public trustee is needed. In such an estate, we take over. So we have even trust causes where the beneficiaries are below 18 years, and we manage those estates in that capacity. And the same applies to management of estates of missing persons. I also would note that there is a contentious issue which is now before the Constitutional Court, and that is the issue of succession registers, which were under our management since 1967, pursuant to Statutory Instrument number 150 of 1967 that vested the management of succession registers. I'm sure many members of the Law Society in their practice in this area have come across issues of administration of estates of deceased Baganda who died before 1967. So you find somebody, a client, who wants letters of administration, but the deceased died in 1940 or 1930 or 1950. And there has been challenges, practical challenges, because the Office of Administrator General eventually, on the advice of the Attorney General, ceased issuing certificate of no objection to people who died 67 and below, because according to the Attorney General, we have no legal authority to handle those estates. So it is true that lawyers at times are stuck when they have a client whose deceased person died 1940, 30, 20, or 50. But the matter is now in the Constitutional Court, Rufunya Derrick and another versus Attorney General and another, and I'm sure the Constitutional Court will guide on the issue of legal authority to manage estates of deceased Baganda before 1967. So as we are all aware, the Succession Act was amended. Actually, the succession laws, succession-related laws were amended in 2022 after a very long time. For example, the Succession Act had been amended in 1972. So in 2022, it was 50 years since there was any reform in succession law. And in my view, that period of time explains why we have some contentious issues in matters of succession, because the law was stagnant for a very long time. And in 2022, we had sweeping reforms and amendments. And all of a sudden, we are now having very contentious interpretations because of the evolving nature of succession law. So we had the very many reforms and amendments, but I'll just point out the issue of priority of application for letters of administration. As we all know, the 22 amendment, a surviving spouse had a right, automatic right to apply for letters of association a certificate of no objection from the employer. And that was actually confirmed by the Supreme Court. So the law was surviving spouse did not require a certificate of no objection in order to apply for the amendment maintain that position of priority, but say that preference by a surviving spouse. I can see people saying nice. Yes. Yes, so I was saying that the right of a surviving spouse now to apply for letters of administration is now subject to an exception that the Administrator General can disregard that preference of a surviving spouse. And there are now cases to that effect that have tested this new amendment. I think Justice Katie Rima in one of the cases, Sarah Valamaze Nantam versus Kijambu, held that now under the new amendment, a spouse under intestacy has to get clearance from the Administrator General to ascertain his or her fitness to administer the estate. It has been a contentious matter, but evolving case law tends to now confirm that even a surviving spouse now needs clearance from the Administrator General. The other trends that came up was on the principal residential holding and other residential holdings, which provisions are still being tested. There are different interpretations by different judges, but what we know is that now the principal residential holding or residential holdings are not subject to distribution, and nor can you can't distribute them under testacy in a will, nor can you distribute them under intestacy. The principal residential holding is reserved for the surviving spouse and lineal descendants. Both occupancy and ownership is for the surviving spouse and lineal descendants. The other issue that was, of course, introduced was expire of letters of administration. As we all know, that letters of administration now expire after 2 years. Although, of course, there is a certain confusion in the general public, and I think it is our duty, because all grants in Uganda to private administrators, as at 31st May 2022, were given a grace period of 3 years. So there's that confusion of 3 years and 2 years, but all the grants, any grant that was existing in Uganda as at 31st May 2022 was given a grace period of 3 years to expire. So all grants pre-May 2022 are expiring 31st May this year. But all grants that were issued after May 2022 had a lifespan of 2 years. So in other words, some new grants have already expired. Because, for example, a grant that was issued in June 2022 expired in June 2024. So the ones that are expiring in May this coming month, and I'm sure there's going to be a whole pandemonium because not many people know about it. So the 3 years are lapsing next month on the 31st, and all grants in Uganda that were in existence as at 31st May 2022 are going to expire. So there's going to be a lot of issues, I'm sure, and I think the family division, when they discuss this, will talk about that. It's going to be a very serious issue on that. Of course, the Administrator General, for him, he also has grants on estates. For us, they gave us 5 years grace period. So grants to Administrator General granted before 31st May 2022 will expire in May 2027. So it is important that comes out very clearly on expire of letters. We are having, of course, issues, but I'm sure the family division will talk about that. On for example, can you apply for extension of a grant before its expiry? Do you apply for extension after expiry? So those are issues that we are grappling with currently. Then there is, of course, the issue of death of several administrators and executors, which has caused a lot of anxiety and different varying opinions ever since Justice Mubiru held in Pure Clare case, that where one of several administrators dies, then the grant becomes inoperative and should be revoked. So there are issues on that, especially vis-a-vis the provisions of the Succession Act, which clearly seem to say that death of one of administrators does not necessarily lead to inoperativeness of a grant, but actually the office of administratorship or executorship devolves to the surviving administrators. So that is something that is out there for further discussion. Court of Appeal, I think, hasn't been tested in a higher court. Maybe we should, because most of the cases after Justice Mubiru followed Justice Mubiru. Disputes amongst administrators is important because that is happening a lot, causing stalemate in administration of estates. The amendment provided for the Chief Justice to make practice directions, which to my knowledge have not yet been made. Practice directions to determine, to guide or regulate arbitration of disputes amongst administrators. And then I had talked about issues of, for example, probate resealing. The amendment to the Probate Resealing Act now introduces the concept of reciprocity. First of all, before the amendment, only the grants, I think, granted by the Commonwealth countries were subject to resealing here in Uganda. But now, after the amendment, foreign grants from all over the world can be resealed in Uganda, but subject to certain conditions. For example, the amendment says that the law under which the grant was issued, for example, if the grant was issued in Malaysia and you want to reseal it in the High Court of Uganda here in Kampala, it should be ascertained whether the law of Malaysia is not contrary to Ugandan law. So that is one. Two, reciprocity. The principle of reciprocity now applies that you can only receive a grant in Uganda from a foreign country if that other country's laws also allow for reciprocal enforcement of Ugandan grants. So if you are bringing a grant from Canada to reseal here, but the law of Canada doesn't allow a grant from Kampala to be resealed in Toronto, then Kampala will not reseal that grant because there is no reciprocity. There is no reciprocal enforcement between those two countries. And then, of course, there's the contention on caveats, on resealing applications. I think this matter is now in the Supreme Court. Justice Kazare had, I think, ruled in the Joseph de la Haye case that an application for resealing can be caveated like an ordinary application, but the Court of Appeal disagreed, and they said that no, you cannot, because you can't be opposing a grant issued by another competent court outside Uganda. So the caveat that you lodge should not be objecting to resealing as such, but it is for creditors to notify the intending applicants for resealing about their interests in Uganda. I'm glad that this matter has gone up to the Supreme Court, and we await final guidance from the Apex Court. On issues of management of estates of persons with mental illness, we all know that the Administration of Estates of Persons of Unsound Mind Act and the Mental Treatment Act were repealed by the Mental Health Act. So we now have the Mental Health Act that deals with management of estates of persons with mental illness. We no longer have the nomenclature of persons of unsound mind. So it is now mental illness. And many things have changed in that law, because previously the law was dwelling on insanity. Insanity, which is a state of mind in which the insane person has no capacity to manage his or her affairs. But under the new legal regime, the Mental Health Act has ushered in, diagnosis of mental illness doesn't automatically equate to one's inability to manage his or her affairs. So we have all seen that this is an emerging area of practice. I think we have followed the Mohan Kiwanuka case. Actually, that is a case where you realize that courts are very cautious to just declare somebody with mental illness and therefore unable to manage their affairs. So courts are very cautious because, first of all, it can be an area for manipulation where some people can be unfairly declared mentally ill to take away their properties. And the same applies to estate of missing persons. Many lawyers come to the Office of Administrator General when persons are missing and they want to straight away open a file and get letters of administration. But I think the law is very clear that you first begin with a management order where somebody disappears without making provision for the administration of his estate and is not heard of within 6 months. Any relative may apply to court for a management order. So we need to follow that procedure, that we begin with management order within 6 months of disappearance of somebody. And then Administrator General only comes in where there is now presumption of death. So the presumption of death of a missing person under the law is 3 years. So if somebody now takes 3 years without being heard of, then it are declared dead. And the law is that once they are declared dead, then the manager who had got the management order initially has to report the death to Administrator General and cease being a manager And in other words, that would mean that the estate would be managed in accordance with the Succession Act. So, Mr. Host, I just wanted to go through as an overview without taking a lot of time to just give an overview of the current trends through the amendments, and then these other 3 areas that I think members should emphasize. I thank you for this opportunity.
Thank you so much, Mr. Glover Henry. Your discussion was very insightful. We do have a few questions. We're trying to look at the chat, see if people have sent through any questions, but none as yet. However, we do have a question that was sent offline, and maybe I'll just read it out for you so that you can guide us on that. But for now, we're very thankful for your presentation. So the first question is that, in your experience, what are some of the most thoughtful or effective estate planning strategies? Obviously, as lawyers, we are advising clients on planning their estates. So I'd like to hear from you what your thoughts are and what your advice is in terms of effective estate planning. Obviously, we do have wills, but from experience, you see how people usually contest these arrangements. So I'd like to hear, in your experience, what are those effective estate planning strategies that you'd advise, given our society as Uganda, because of obviously polygamy, informal property arrangements, and customary law. What would be your advice in that respect?
The will has been used traditionally as a conventional tool of estate planning, but my experience is that first of all, few people write wills, and then those who write wills write invalid wills. So it is important that we broaden estate planning. For example, the concept of a trust. It is not yet embraced, but in my view, is a very good arrangement, because for it is not ambulatory like a will that it takes effect upon death. For it can start taking effect during the lifetime of the settlor. So to me, I would think I should point out that trust laws, as opposed to succession laws, were not amended. By trust laws, I mean the Trustees Incorporation Act, the Trustees Act, those things that are relating to trusts. For them, they were not amended, and I'm aware that there is an ongoing process of reforming that area. And in my view, once it is reformed to align with new challenges, the concept of a trust is going to be very important, because there, even if you die, the property will continue being managed by the trustee for the benefit of the beneficiaries. The other is the co-ownership of property. Co-ownership of property, either joint or common property, as we all know. I've seen many people use it as a tool now that somebody registers the property, for example, in his or her joint names with the children. So whoever dies, the principle of survivorship applies in joint tenancy, which doesn't now need the process of administration. There's no need for probate. The property automatically devolves to the surviving. So if a father, instead of, let's say, bequeathing his land to his 4 daughters in a will, which would require probate, which is a very long process, he registers himself as a joint tenant with the daughters. Of course, no one determines who will die first, but whoever dies remains for the survivors. That is for joint tenants. Then there are some people who deal with the common tenants, which resolves the matter halfway, because it would mean that if you are common tenants, the principle of survivorship doesn't apply, that when one dies, that property goes to their estate. So co-ownership is the second option that people can use. Other countries, actually, of course, they use the concept of the company, where family property is now owned by a company. The beneficiaries, they would be beneficiaries under a will, are now shareholders, so that even if anyone dies, the company still remains a going concern. It is something that is very, very important, that we advise our clients beyond the traditional tool. For example, even the courts, and it is good that the court is here. For example, Justice Bashaija became very innovative in Kabagambe versus Kabagambe, where they introduced that concept of a simple trust. We all know that in Uganda, many people write wills which are invalid. They are not witnessed. They have one witness, and the law is so strict that if there are not two witnesses, a will is invalid. But Justice Bashaija was, in that case, postulated the simple trust doctrine, that if somebody has made writings during his lifetime, and those writings are very consistent and establishing that a beneficial interest to certain people, you shouldn't just overlook them because they are not testamentary dispositions, that they are not witnessed by two, and therefore it is not a will and not enforceable. So for him, he said that it can be enforced as a simple trust. And in my view, if we adopted and embraced, so many estates in Uganda would fall under actually simple trusts. So it is important, Mr. Host, in answering that question, that we broaden beyond the tools of estate, the conventional tool of estate planning, which is a will, and go for trusts, company incorporation, gifts, intervivals, provided are well done to avoid challenges in court, and then co-ownership of property. Thank you.
Thank you so much. We do appreciate that insight. Unfortunately, our time is fast spent, but thank you so much for that insight, and we are grateful for your guidance. You've been a wonderful substitute for the AG himself, and please convey our regards and gratitude for this presentation. It's been very insightful, and thank you so much. And you do raise very pertinent questions, especially regarding expiry of grants and what are the next steps. Our advantage is that I think we're muted. We are muted, actually. Yeah, you can be heard. Just need, no. I think we need to be unmuted. Muting, we're muted. Apologies, we were unmuted. Mr. Henry Clover, we are grateful for your insight. And like we're saying, you've been a wonderful substitute to the AG, providing insight on that discussion. And please convey our gratitude to the AG himself. We are appreciative of your insight. So the questions you raised, and while I was listening to your presentation, you raised questions regarding expiry of grants and substitution of administrators upon death. At least, luckily for us, our next presenter is a person who sits on the bench and is going to provide valuable insight in that regard. So thank you very much, Mr. Henry. We're very grateful. We'll close that session and permit me to transition to our next presenter, who is His Worship Samuel Olumo. By way of introduction, the person seated next to me is a person of versatility in legal practice, both experience at the bar and experience at the bench. A person who is both a judicial officer and obviously a governance expert. He's bringing to the table here today over 14 years of rich and cross-cutting experience in justice administration, whether in the courtroom or in legal education or human rights advocacy or at the bench. Permit me, before I invite him to speak, to briefly share his incredible journey by reading out his bio so we can know what experience he brings to the table and what solutions he gives us today. So His Worship Samuel Olumo is a highly self-motivated and multi-talented legal professional with over 14 years of demonstrable post-qualification expertise, focusing on legal research, practice, analysis, law and policy in a range of areas, including governance, institutional management, law, administration of justice in both regional law and policy. He's presently a deputy registrar at the Family Division and has previously served as a principal legal officer at the Judicial Service Commission. He has also served as a corporation secretary at the Uganda Printing and Publishing Corporation, which you all know as UPPC. He has also been the executive director of the Uganda Law Society and Legal Aid Project, a board member of the National Coalition of Human Rights Defenders Uganda, and member of the Jail Laws Technical Committee. He has also held the position of the head professional development and members affairs at the Uganda Law Society, where he managed key reforms in the CLE program. He has also served as a member of the East Africa Law Society Strategic Litigation Committee for over 4 years. He holds a bachelor's degree from KIU, a postgraduate diploma in legal practice, a postgraduate diploma in management, and a candidate for Masters in Management Studies at UMI. I'm pleased to welcome His Worship, Samuel Olumo, to the platform.
Thank you, host Mr. Philip Saja. I would like to thank the Law Society for inviting the judiciary, specifically the High Court Family Division. I'm here to represent the head of division who was not able to participate at the CLE training this morning. That's Justice K. Chirima. And the ULS had invited His Lordship to speak on management of estates, practice challenges and perspective from the court. As noted by my colleague, Mr. Henry Kloba, who has just spoken, we know that the Succession Act was amended in 2022, which brought on board a number of reforms in succession law and estate management. And in my opinion, I would like to state that estate management to me would relate to transfer of wealth from the wealth creator to the surviving family members, who may be his or her spouse, the children, and the dependents. And of course, this process must be well managed in terms of ensuring proper transfer of this property and assets to the surviving spouse, as well as the beneficiaries, who may be the children of the deceased, surviving spouse, or dependents. And this process can purely be done through two modes, which can be letters of probate, where the deceased left a will, or through letters of administration, where the deceased died intestate without leaving a will. And of course, this must be issued by a competent court. So I'll be speaking for the High Court. I know that the law provides for small estates as well, which are always granted by the magistrates' courts. So those are not an issue now. We'll be talking about the process for the High Court. Ideally, as alluded to by Mr. Henry Kloba, what happened is that when a person passes on, we expect that the death must be reported to NERA and the family or the surviving spouse or beneficiary should be able to get a death certificate. The death certificate should then be taken to the Office of the Administrator General to have the family open up a file so that they can begin that process if the person has died intestate. But if the person has left a will, for example, it means that the family can come straight to court as long as the will is valid. As again alluded to by my colleague Henry Kloba, because if the will must have, it must be dated, must have executors appointed, but we'll discuss that along the way. So as we go to the AG for the process of the kono, we'll need a death certificate issued by NIRA. We'll need a copy of the will, if there's a will left by the deceased. We'll need a marriage certificate. If the person intending to apply is a spouse of the deceased, and then we also need a list of beneficiaries and their identification documents. And they must carry along with them a letter from the local council or their LS1 chairman to inform the AG that the people who are coming to him or her in the AG's office are actually people who are known to the local council area. So the AG should ideally be able to either hold the meeting himself or herself, or be able to delegate that role to either the town clerk in the area where these people reside or live, or to the chief administrative officer of that district. For example, the family division we've been dealing with mainly Wakiso, and I know that Wakiso has now been given a high court circuit held at Nabweru. We're currently transferring files to Wakiso High Court at Nabweru, but we have been having most of these estates around Wakiso hold their meetings at the cow of Wakiso. The town clerks for the divisions have been supporting the AG in holding these meetings, and they send back the report to the Auditor General indicating the persons preferred to be appointed administrators by the family, and they should also have their consent attached to that report, after which the Office of the Administrator General should be able to give them a certificate of no objection. That kono will then be able to facilitate the family to come to court and be able to present a petition for letters of administration. As alluded again by my colleague Kuloba, is that the amendment provided that whereas the widow has a preference as the surviving spouse or the widower, if the deceased died intestate, the widower or the widow is still subject to vetting by the AG to make sure that they are fit and proper, and also to ensure that there are no other interested parties or other beneficiaries. Sometimes the deceased may have had a mistress out there, and the wedded wife is in the house. So usually when the person dies, these people come up. So that vetting process is meant to ensure that all the people who are interested, all the beneficiaries are brought on board in terms of participating in the process to avoid litigation after the grant is issued. So the cow should be able to have that meeting concluded and then forward these people back to the AG. The AG shall have them do that kono process, and then they file a petition in the court. The court should be able to give them a notice, which should be published for about 2 weeks. After that publication, of course, if there are no caveats, the court should be able to have the applicants identified and issued with a grant. In terms of the identification process at the court has a requirement which I would want to call a checklist. And usually we have the general requirements which we expect as the registrars in charge of identification before the applicants go to the judge for confirmation and issue of the grant. These requirements include the petition. We expect a notice of the application. We expect that a declaration must be attached, as well as the administration bond. The death certificate has to be a must for all these applications. The advert should have been advertised in the paper of wide circulation. And the court from 2023 has been insisting that we should be able to have these photographs in color so that the court or the registrars can be able to properly identify the persons who have come to court. Sometimes you get photos where you can't be able to tell the person who is appearing before you as compared to the photograph in the newspaper. That's why the court has been able to insist on colored photographs to make sure that we are able to properly identify these people and then have them go and manage their estates. The other requirement is the list of properties they intend to administer, as well as title deeds. Of course, the court should be able to give a grant to petitioners or prospective administrators. They should be given a grant for property that belongs to the deceased. The court should not be able to encourage anarchy by encouraging people to go and fight with the neighbors to look for what to administer. That is why the court needs its title deeds on the file to be able to confirm the ownership of that property they seek to administer. The other requirement is that the matter must fall within the jurisdiction of the family division. Previously, we have been handling Kampala and Wakiso, as well as Entebbe. But with the opening up of the new court circuits in Entebbe and Wakiso, the instrument was issued by the Honorable Chief Justice, so that clearly maps out the areas where Wakiso will cover, where Entebbe will cover, and where the family division will cover. In terms of intestacy, we expect requirements which include the certificate of no objection issued by the Administrator General. We expect a family consent signed by the family members, appointing the people who are appearing before court to petition the court. We expect certified minutes of the family meeting, either with the Administrator General or with the town clerk or the cow. We expect a marriage certificate where applicable if the applicant is a surviving spouse, for example. Properties, again, we expect those to be clearly listed. Copies of the title deeds or agreements if the properties are not yet transferred, or they are kibanja, bibanja. And then, of course, we expect a fair value of the estimate indicated. You may not be able to do an actual valuation, but we shall expect that there should be a fair estimate given in the petition for letters for administration. In terms of intestacy or letters of probate, we expect a valid will which should be translated. If it was written in the local language, for example, that should be translated to English. The will should be appointing the executors. We expect a consent to the will by the witnesses or the verification. Identification documents of the petitioners or the executors, as well as the witnesses of the will, who must appear for identification. The petition should be able to conform to the will of the deceased. And with the amendment, as alluded to by my colleague Kuloba, the petition for probate must be brought within 1 year from the date of the death of the testator. But of course, this should apply from the time that the amendment came into force. After the grant is issued, of course, the court usually tries to educate the administrators in terms of what the law expects them to do in terms of their duties as administrators. And this will include for them to list all the properties of the deceased person, the debts or debtors, creditors. We also expect them to pay all the debts of the deceased. We expect them to provide for the immediate needs of the beneficiaries, especially where there are younger children or minor children. We expect them to keep estate property from being damaged or destroyed, collect all money and income due to the estate, keep proper records and accounts of all dealings concerning the estate, as well as transfer property to the beneficiaries in accordance with the law, and file an inventory and final account. In terms of their dealings with the estate, filing the inventory and account has been a challenge, as I could note, that most of these estates, my colleague alluded to, older estates, were not filing their accountabilities and inventories or final accounts. And we have been having an influx, one for filing inventory out of time, filing the accounts out of time. And now what is coming up is now the issue of expiry of grants. And currently, most of the applications we receive on average about 150 per day in terms of registrations, and about 80% of those are for extension of letters of administration which are about to expire on 31st of May next month. And I also know that the quota has already been extended of those grants. I know that some grants have been issued for some of the estates who have been able to bring up the applications in time. The applications for leave to file inventory out of time, as I noted earlier, is that the judges, their lordships are dealing with these applications. There are quite a number now, because the administrators do not comply with the requirements of the law to file them within the 6 months provided for in the law. So the court, within its discretion, has been extending these applications subject to the consent of the beneficiaries. These applications are filed for leave. They must make the beneficiaries respond to their application so that they tell the court what actually happened, why they failed to file the inventory within time, and where they consent. That makes the extension even easier for their lordships to deal with. In terms of probate, as listed earlier, we expect that the will, of course, must be valid in terms of the legal requirements. The will must be translated to English in terms of Section 241. We must have executors. The petition must be verified by the witnesses. It must be made within 1 year, as I noted earlier, in terms of the date of the death of the testator. And the law clearly states that if the executors fail to apply within 1 year from the date of the death of the testator, then the beneficiary or beneficiaries listed in the will are free to come to court and apply for letters for administration with the will annexed. So this means that they have to go to the Office of the Administrator General and obtain a quono, but with the will annexed for distribution of the estate in terms of the wishes of the deceased. As alluded to by my colleague Kuloba again, is that the grants of probate, which were issued after 31st of May 2022, are now issued for a period of 2 years. And I know that we have been rejecting some requests for verification from the Ministry of Lands, requests for certifications from law firms, from the banks, on account that some of the estates for which they are seeking a verification or certifications have had their grants expire. This expiry began last year for the grants issued after 31st of May 2022. So it means that if the grant expired, the parties have to apply afresh for a new grant. The extension should have been admissible if they had filed the application before the grant expired. And I would like to note that the exceptions to the 2-year expiry of the letters of probate or of administration relates to estates where they are purely minor children, where a guardian applies on their behalf, who will keep the estate for the minor or for the residual legatee until they are up to maturity age or the age of 18 years. So those estates may not be subject to the 2-year expiry, as well as estates where they are going to receive pension, because pension, in terms of the Pensions Act, should be received about 15 years from the date of the death of the testator. So that means that for those two areas, the law doesn't require these people to come and do an extension. But if there are other properties, then they have to manage them within the 2 years provided for in the law. The court has been having a number of suits and caveats placed on applications. So for a number of suits, for a number of estates, you may find that the estate has a lot of property which is going to waste. So sometimes the court has been able to appoint administrators prudentially to be able to manage the estate until the administrators have been appointed. Of course, these people will have the powers to manage the estate, except that they cannot be able to distribute the estate property. And they're always subject to the control of court, that they must account to the court on what they are doing. My colleague Kulaba discussed about caveats, but of course the intention of the publication is for the public to know that a person has applied for management of a particular estate. So any beneficiary or interested party out there can be able to come back to court and be able to place a caveat on the estate, to be able to present their issues to be heard by the court, or state their reasons why that grant should be issued to that person or to the petitioners in court. Of course, when the caveat is lodged there, we don't usually do anything. When the caveat is lodged, we usually ask these people to either go to mediation. If they can agree on what should be the way forward, then we encourage that. Or we ask them to file a suit as provided for in the law. Because the law allows them to file a suit by either the petitioner or the caveator within 6 months from the date of the caveat being lodged in court. So if they're able to file a suit, then the suit should be able to be heard by their lordships and be able to establish whether the grounds have merit or they don't have merit. Or the petitioner can file a suit to have the caveat lifted. In terms of what's happening at the court now, what I would call best practices is that we have been promoting mediation, especially for estate management throughout the process. If there is a caveat lodged on an application, the court has been encouraging mediation between the petitioners and the caveator, so that if they can be able to agree on who should be able to apply for the grant from court, then that should be the position they should be able to present back to court. The court has been able to reduce waiting time for the grants, and currently the court policy that after identification being successful, the grant should be issued on the same day. We've been able to have a consents in terms of the mediation processes attended to or confirmed on the same day. We have judges on duty every day to attend to these consents, as long as they comply with the prayers in the plaint. I know some of the lordships have been sending the parties back to adjust their consents to make sure that they are in line with the prayers in the plaint, because sometimes the consents come and present the proper distribution of the estate, which wasn't in the plaint. So for this, the lordships have been sending the petitioners or the parties back to adjust and then present the consent for endorsement. The court has also encouraged an open door policy for all stakeholders, and also having a judge on duty to issue the grants, having registrars on duty every 2 weeks to support the processes in terms of queries. In terms of challenges we face with the process, we've been having a number of fraud or forgery cases arising from forged death certificates, The court had taken a very stern stand on this, and we had many people arrested, culprits arrested, and this has now come down in terms of presenting a fake death certificates by the petitioners. The challenge we have faced as a court is failure to file inventories within the time and the final accounts. This has led to multiplicity of applications which are clogging the court. Some estates will not have a number of beneficiaries, and sometimes even after AG has vetted them, they still come and fight in court in terms of who should be granted letters of administration. The court continues to receive a few applications for probate, which we think should have been the trend now in terms of proper planning for the estates. We also receive false declarations of the values of the estates, and most times we request the petitioners to amend the value, and either amend the petition or the court notes the correct fair value of the estate before the file goes to the judge for confirmation of the petitioners or applicants and issue of the grants. The court has also noted that there has been a delay in terms of administration of some estates. We are getting applications for extensions for very old estates of 2000. So which means that the administrators got a grant from court and went and did nothing. So people are coming now to do the extension to enable them conclude with the administration of their estates. In terms of conclusion, I would note that the Succession Act, as amended, has facilitated a fair and efficient distribution, stock management of estates, while at the same time protecting the rights and interests of the surviving spouses, descendants, dependents, as well as the customary heirs. From the court, from the division, I would like to encourage us, members of the bar, as well as stakeholders, to embrace the law as amended for the proper and orderly management of estates in Uganda. And we also look forward to continuous engagement with you, especially those who practice at the family division. Secondly, we would like to request you to encourage your clients to plan well for their estates in terms of one, writing wills in order to leave their houses organized. What I can say is that death, for as long as day follows night or night follows day, it means that all of us are candidates for it. So it's the best thing for us to do to organize our estates before that time comes. I thank you for inviting us and listening to us. Thank you, host.
Thank you so much, Your Worship, for that insightful discussion. And obviously, we are very pleased to tap into your experience, especially at the bench, because you do interact with these problems on a daily basis. So thank you so much for that insight. But Your Worship would like to, again, like we say, tap into your experience at the bench and pose a couple of questions. We have a few questions that have been sent through in the chat. One is anonymous, so maybe I'll read it out to you, Your Worship, for your guidance. The person says that regarding the requirement for family consent for a person to apply for letters, a widow of 30 years has since 2023 failed to get letters because her in-laws refused to sign the minutes to permit her to administer. What would be your advice? That is an anonymous question that has been sent through. The second question, Your Worship, maybe I should permit you to answer that one, and then I'll go to the next.
Well, thank you. Usually, the family consent is meant to make sure that all beneficiaries of the estate are on board in terms of the process. So if the widow has if she's a widow in terms of legally married to the deceased, then I think the court should be able to dispense with the family consent, because if the widow has a marriage certificate and she has children who should be able to support the process, then the widow should be able to come straight to court. I know that there are instances where the lordships have been able to grant. I know of a case where applicants went to the AG, and the AG took over 1 year to give them an objection. So they applied direct to court, and the court actually waived that requirement in terms of Section 5 of the AG's Act, because it gives a time period within which the AG should issue a corner. So if they don't issue within that period, then they can ideally come straight to court, because it appears that AG would have failed in its duty. So for this widow, in my opinion, the widow should be able to come to court and file an application. She should be able to be identified, and the lordship should be able to verify the widow and be able to issue the grant.
Thank you, Worship. I hope that answers the question. We have an additional question, Your Worship, and I'll just read it. It's coming from the chat. It's from a lady called Alzik Namutevi. The question is that if in respect of a company, the memats provide that the only person, or maybe the persons who should take on the shares of a deceased have been mentioned in the memats, would another person in the family try and have the shares transmitted to them upon death?
Thank you, Namutebi. I think for companies, if the deceased has clearly indicated that those shares are for person X, then the share should go to that person. I know I handled a reselling of property coming from Kenya, and I think this family had shares at Uganda Breweries. So the articles and members were very clear. So we handled a resale, and the resale was issued for them to manage their shares at Uganda Breweries. So if the articles are very clear, then that property should go to the person listed in the company documents.
Okay, thank you, Worship. Your Worship, in your presentation, your insightful presentation, you mentioned obtaining the kono from the AG's office. I think a question which creates a lot of practical challenge is a situation whereby a kono has been granted to, let's say, 3 administrators. Those administrators, the 2 are willing to pursue the application for letters, but there's among those given the kono, there's an unwilling proposed administrator who is taking their time to apply for letters and is frustrating the process. What would be your advice to the other 2 administrators who are willing to apply while facing a situation of an unwilling administrator? So the administrator doesn't want to renounce, but they're just simply dragging their feet with the application process. How has the court dealt with that?
Thank you. In terms of lack of cooperation between prospective administrators, we've received such cases, and previously we used to send them to mediation. We used to send them to the office of the AG with a view of removing the one who's not cooperating. But I also know that, and in my view, that their lordships have unlimited power to be able to issue a grant to only the 2 people who are willing to manage the estate, because these estates should be managed, they should be administered, and should not go to waste. So if one of the prospective administrators on the corner is not willing to cooperate with the rest, then in my view, their lordships could, in their verification, be able to issue a grant for the 2 who are willing. That's the same as having issued a grant to the 3, and then one becomes a problem to the 2 to administer the estates. The law allows them to come back to court, file an application, and have the 3rd party who is not cooperating with the 2 removed from the grant. So in the same way, their lordships have the jurisdiction and power to issue the grant to the 2 who are willing to manage the estate of the deceased person.
Thank you so much, Your Worship. We do have more questions coming in online. I think we have a question from Elivason Nalumu. The question is that there are instances where, in cases whereby a case is between party A and party B, court then declares that a will is invalid. What would a third party that wasn't party to the initial suit, what would be their remedy in such a case if they want to challenge a holding to that effect?
In terms of the court declaring the wills invalid, it means that if there's a third party interest, it means the party has to wait until the court has appointed administrators for that estate. Because if there is, for example, an application for revocation, and there's a third party who's supposed to be the data of the estate, suppose to get some money from the estate, then it means that the party has to wait until the court appoints administrators for that estate. Because if the will had given that person and the will has been declared null and void, then it means you can't take benefit out of it until the family has had administrators. They may decide to use the will for distribution, you see. But if it's declared null and void, or the will is the will is declared void, then it means null and void, then it means they can't take benefit from the will at that stage unless the court has been able to appoint new people to manage that estate, and they're able then to be able to administer it and take note of the data of the estate, as well as move out to the creditors and bring money to the estate which was owing to the deceased administrator or testator.
Elivason, I hope that provides the answer that you seek. We also have another question from an anonymous listener. The question is, what constitutes distribution, especially if family prefers to keep property collectively? I don't know, I think what I seem to...
What constitutes?
What constitutes distribution, especially if a family prefers to keep the property collectively? I think they don't want to distribute, but perhaps they want to keep the property intact without distribution.
So they want to manage. I
Correct.
think what happens if the family elects to manage the property, they don't want to distribute the property, then it may mean that they may have to go for either trust, or they may have to go for co-ownership, because the grant will be issued by the court for 2 years. So after the 2 years, it means that you're no longer the administrator of that estate, or you're no longer the executor of that will of the deceased person. So for you to move forward with the management of that property, it means that either you're going to agree on trustees, so appoint the trustees to manage the estate on your behalf as beneficiaries, or you may have, if it is land, for example, then you may have to register the property in your names as co-owners in terms of either joint tenants, but of course joint tenants won't be the best, because I'm sure they'll be interested in their shares. So the option will be for them to go for tenants in common, where their shares are known in terms of what they'll get from the estate when they agree to finally give it to the beneficiaries of the estate.
Thank you so much, Your Worship. I'll just read the next question.
Yes.
The next question is from, again, Zik Namutebi, who asks that, what is your advice to beneficiaries who have a settlement order issued by court, and despite that, the administrators have gone on to alter the portions of their shares and even unwilling to transfer those portions? What would be your advice in that respect?
Because usually the consent is the agreement of the parties, which the court will endorse in terms of implementation by the administrators of the estate, or give the beneficiaries their shareholding. So it means that if they have refused to implement what the beneficiaries have agreed, then they can be able to come back to court and file an application to have those people who have been appointed administrators removed, and people can be appointed. Because if it's a consent, it means that the parties have agreed to whatever is in that the four corners of that paper. So it means that you're not going to coerce. It means that they have to come back to court, either set aside the consent or appoint new people who are going to implement the consent of the beneficiaries and the administrators, who may also be beneficiaries of the estate.
Thank you, Worship. We then have another question coming in from Letitia. She asks that how can court aid with beneficiaries that refuse to sign beneficiaries' consent to transfer estate land?
Ideally, in terms of distribution, if the family has sat and agreed that person X should take this, person K should take this, then the administrator should be able to implement that. But if they have refused to sign out the consents, most times I've had a matter where Justice, it was actually handled by Justice Jean, and she handled the mediation. And after the mediation, the executive accepted to give the other beneficiary her title and agreements. So it's purely about engagement. But of course, where it fails, then they have to file either a suit and application to have their share realized from the state.
Okay, thank you, Worship. There's been a question from Prosi. I think she's been asking since morning. I see it has come back. Unfortunately, we had missed it. Apologies, Prosi. She's asking that what happens in instances where, for example, the third schedule provides conditions for the surviving spouse while occupying residential holding. It bars them from letting it out, renting it out. What happens in instances whereby she's letting it out in contravention of those schedules? Is she still entitled to reside in the residential holding?
Thank you, Prosi. Of course, the schedule, the law is very clear in terms of the parameters and the boundaries for the residential holding. So if the party is operating outside those parameters, then it means they are in breach of the law. So it means that that right to remain in that holding is being thrown out of the window, unless the beneficiaries of the estate are agreeable to that position. But if they are not, then they can be able to file a suit in terms of enforcing the law and have the widow come out clean. Whether she wants to move out, if she should stay in, then she must comply with the parameters or the boundaries set out in the law.
Thank you so much, Prosi. I hope that answers your question. We have one last question, Your Worship. This is one that's been sent offline. And I think the question you spoke about, even I think Mr. Kuloba raised it regarding expired grants. You have people that have woken up now and realized that, okay, now I need to extend. However, some grants that expired last year, I think the policy is that you can't extend after the grant has been expired. I even think Mr. Kuloba had the same question. However, obviously there's concern by some advocates saying, why do we have to go through a process afresh of obtaining a fresh grant of letters? Is there room for inherent jurisdiction of the court to be invoked, especially in situations whereby the state is nearing completion? And let's say there's no objection from the beneficiaries, they're happy for them to continue the administration. Is there room of flexibility by the court to extend those already expired grants to permit completion of administration?
Thank you, host. In terms of expired grants, I know that, as alluded to my colleague Kuloba, and as I noted earlier, that the grants which were issued before 31st of May 2022 will expire next month on 31st. But we have grants which were issued after 31st of May 2022. Those have already begun expiring. And the court has been receiving applications from the administrators of these estates to extend their grants. And of course, the extension must be consented to by the beneficiaries of the estates. So what's happening is that for you to file for extension, the application for extension must be filed in court before the grant actually expires. It should be filed in court before the grant expires. then the court should be able to hear from the administrators, hear from the beneficiaries. If they consent, that's even faster for the court to be able to handle the application and at its discretion extend the grant. And I know court has been extending some of these grants. If the grant has expired, it means that you cannot extend what has already expired. It's like abatement of a suit. If the suit has abated, it means it's dead. You can't extend what is dead. So it means that the family or the administrators must begin a process of getting a fresh grant, which may need them going to get a new corner from the office of the AG. Because the longer the estate takes, the more it gets complicated. So at that point, after 5 years, 10 years, the court cannot use its power to extend that old grant, but rather to send the people back to AG to have a new grant, fresh grant issued, if the grant has expired. But if it's still within the period, which is the 3 years for the old grants, you have 2 years for the new grants, and the AG was given 5 years for the old grants. For the AG, they still have time. So if the AG feels they haven't finished their administration, then they can apply for extension. But for the AG, it's too early for them to apply now. But the ones who are receiving now are for those which are expiring 31st of May. And like I noted earlier that most of the filings we are receiving now relate to extension of these grants. And we had a stakeholders meeting with courtesans meeting with members of the bar and other stakeholders, and their lordships were encouraging the practitioners, members of the bar, that, for example, if you want to apply for filing inventory out of time, and yet the grant is about to expire, then it will be best for you to actually apply for extension and have the prayer for filing the inventory as well, and also have a prayer for filing of the final account, so that they are in one application, as opposed to bringing multiple applications for the same estate, and yet the judge could be able to deal with them together in one application. Thank you.
Thank you so much, Your Worship. I know our time is fast spent. There's still more questions, but we are very grateful for your practical insight. So many grants have already expired. Some are expiring just next month. So definitely your insight will be very valuable in how we proceed to deal with these expired grants. And Your Worship, maybe just as your parting shots, we had asked Mr. Kulova earlier to also give us his thoughts on effective estate planning strategies. There's people, what would you tell a person who holds a chibanja, but they're thinking of establishing a trust? A trust's very effective strategies for smaller estates. What would be your recommendation in terms of estate planning?
Thank you, host. In terms of estate planning, is my opinion and view that for us who are still on earth, it's important for us to plan for our estates. And I would suggest that, of course, the trust is one of the options. We've been advising the estates which are having wrangles in court, where we hold a mediation, where there are disagreements, or those who seek guidance from the court in terms of managing their property post the 2-year expiry period of the grant. Because the grant will be issued for 2 years. After that, they should be able to move on, either distribute, but if they choose to want to manage, then we shall advise them to want to do a trust. And a trust will be effective for big estates, so that the family sits, agrees, and appoints trustees who are going to manage their property in trust for the beneficiaries. In that way, it means that the grant will expire, but then the property should be able to be transferred to the trustees, who will hold it for the benefit of the beneficiaries of the estate for as long as they want the trust to live. If they choose to want to sell after 5 years, for example, then the family can still meet and then make a resolution, and then they can pick out the property, sell, and share the proceeds. Then secondly, is planning for your estate while you're alive. You can do gift inter vivos, for example, gift inter vivos by giving out your property, distributing when you're alive. I handled an estate, I think, last week where the widow, a lady had actually given out her estate to all her children while she was alive. And she left only the home and one other property, of which the home she gave to the heir, but said that the other property should be sold by all the beneficiaries and shared equally. So in that way, she was able to organize her estate. And when the children came to court, in fact, I could actually tell that the family is in harmony, they're in peace. So I think one of the issues should be to have distribution done when you're alive, transfer to your children, and then maybe leave the residential holding, which they can
Thank you so much. Thank you so much, ladies and gentlemen, for your patience. So we do have an echo? Okay, I think we are clear now. Thank you so much for your patience. We experienced a technical glitch, but we're now back online and ready to take it on. We do have our next presenter ready to take it on, and permit me to introduce her. She's a person that's not new to this. She has honed her legal and advocacy skills across prestigious institutions, including Makerere University, Columbia University in the USA, the University of Pretoria in South Africa. She also holds a postgraduate diploma in legal practice from the Law Development Center. Her work is grounded in real impact, whether representing survivors of violence, abuse, or taking on complex cases like the 2019 cross-border retrieve of a trafficked Ugandan woman, her remains which were in the Middle East. Her tireless dedication has earned her a couple of international awards, including the French and German Ellis Treaty Peace and Reconciliation Award in 2020. Today she will speak to us on adoption, emerging areas and best practice, drawing from her wealth of legal experience and grassroots advocacy to explore how the adoption landscape is evolving in Uganda and guide us on how to move forward in that respect. Please join me in welcoming Ms. Prima Kwagala to the platform.
Thank you. Always an honor addressing members of the society. I trust many online have practiced and done a lot of this as well. But as a practitioner in the human rights field and primarily working with women and girls, I find myself at the center of a discussion of adoptions or adoptions gone wrong, or a misunderstanding of what happened between a birth parent and an adoptive parent. Most of our cases, though, always end in mediation, discussion, because these being familial and emotional issues, not so much precedent is online. Nonetheless, we've had some controversies between the bench, the bar, and communities when it comes to cases of adoption. So I'm excited about the discussion. When it was proposed to me, I'm merely here to share what I have learned, what I have seen, what I am seeing, and even better, what I could learn from some of you that are getting bread and butter from this trade. So I will start my presentation. I hope the admin can put it up here. I looked up the definition of adoption in our law, both the Children's Act and the rules on adoption. And unfortunately, I did not come across any that is prescribed by the law. But I looked at the definition from dictionaries. I looked at the Oxford Dictionary, and they defined adoption as an action or fact of legally taking another's child and bringing it up as one's own, or the fact of being adopted. The second edition Black's Law Dictionary says it's an act of one who takes another's child into his own family, treating him as his own, and giving him all the rights and duties of his own child. This whole process is a juridical act creating between two persons certain relations, purely civil, of paternity. And in my own definition, being a gender person, I said maternity as well, because I know so many women. If anything, in my practice, it's mostly women that are doing adoptions. So to the dictionary, instead of paternity, I also added maternity and filiation. So generally, For so many reasons that I may not be going into, people choose to adopt children, either because they don't have children of their own, and those giving up children perhaps are not able to care for those children and feel that someone else better placed might be able to care for those children. And so the law provides for ways and means that that can happen. At the back of my mind, I'm reminded that in our communities, many times we adopt children, but we do not go through the legal process. For a legal process to happen, there is really extreme exceptional circumstances where a child is placed, and because we want to promote the best interest of the child, the state has an obligation to put in place regulatory procedures and mechanisms through which this child can also receive a family that can better care for them. So in the Ugandan context, the law applicable is the Children's Act, which is currently in the new laws released by the Uganda Law Reform Commission, is Chapter 62, formerly Chapter 59, and Part 7, Sections 44 to 55, detail or provide the regulatory procedure for how one can adopt a child. The other legal or statutory instrument in place is the Adoption of Children Rules, 1997. They were made under statutory instrument number 52 of 1997 by the then Chief Justice. And they provide that an application for adoption is made by petition under rules, as per the rules provided. The civil procedure rules are very applicable to this process, but section or clause 3 of those rules is what I laid emphasis on. It provides for jurisdiction, which is the Chief Magistrate's Court, where the petitioners who wish to adopt a child are Ugandans, and the child is a Ugandan too. You can just walk to a Chief Magistrate's Court either as an individual or through an advocate and fill the form to adopt a child. The petition is done ex parte, but there's a requirement for you to serve it on the birth parents, the guardians, or persons involved in raising this child or children. For non-Ugandans, the jurisdiction is the High Court, and once again, the petition can be made ex parte. I keep underlining ex parte, by an individual or through an advocate. Clause 3, subclause 4, or subsection 4, requires the presence of a probation and social welfare officer throughout the application process. They are supposed to be present at the ex parte hearing and to attend all subsequent proceedings as directed by the court in order to advise. I thought the other issue I needed to highlight was who can adopt a child. For many lawyers, adoption, they usually hear or read about it, or the last time they interacted with it is the time they were in law school. For some of us who were there too many decades ago, that can be a challenge. So I thought I would highlight who can adopt a child. For you to adopt a child, you must be at least 21 years older than the child you want to adopt. But the law requires under Section 45 that you don't have to be married to apply, but if you are, you can apply as joint applicants, and you should have attained the age of 25 years at least. And if the application is by one of the spouses, the other spouse ought to consent, but it's not a requirement that the other spouse consents. One of the parties can actually go ex parte or independently to do the adoption without the consent of the other. An adoption order, the law says, shall not be made in favor of a sole male applicant in respect of a female child, or in favor of a sole female applicant in respect of a male child, unless the court is satisfied that there are special circumstances that justify as an exceptional measure the making of an adoption order in that regard. If a woman who wishes to adopt a young man without the consent of another spouse, alone as an individual, might be problematic for purposes of the welfare of that child. Also, the court requires that you should have fostered this child or stayed with this child, kept this child for at least a year or more. And I believe this is so you're well acquainted with how to care for this child, when to intervene, and the child is okay staying with you. The probation officer is required to submit a report to, as I mentioned earlier, advise the court in whether or not they should consider the application. The court may also, in addition, require some other person or local authority to make a report in respect of the adoption application. As we always say in the legal fraternity, there are always exceptional circumstances to general laws. So clause 6 of section 45 says, except where the application is by spouses jointly, an adoption order shall not be made authorizing more than one person to adopt a child at the same time. Again, in the best interest of the child, the confusion that comes with having multiple personalities carrying an adoption order might bring some problems. Section 45 is in respect to Ugandans, and 46 provides for inter-country adoption. Non-Ugandans are allowed to equally adopt Ugandan children, and I think this is where we have found the biggest challenges as practitioners. The person who is not a citizen of Uganda may, in exceptional circumstances, and I like the new versions of the Children's Act and amendments that have come, that are insisting that the people coming from outside to adopt children from Uganda should, ensure that for at least 1 year you have stayed with this child, that for at least a year you have fostered, and fostering the child under supervision. Unfortunately, if you look at under our Ministry of Gender, which I believe is the one that recruits probation and social welfare officers, supervision is a problem because you only have one person at a district, supervising or being in charge of children's affairs. So the reports have some problems sometimes on whether or not the person was taking good care of the child. The person is required not to have a criminal record. They should have a recommendation concerning their suitability to adopt a child from their country or their country's probation and welfare officer or competent authority, depending on the jurisdiction where they are coming from. The person, in this case the foreigner, must certify the court that his or her country of origin will respect and recognize the adoption order if given from Uganda. The other thing I noticed around the law on inter-country adoption in the 2016 amendment, I think it should be clause 6 of section 46, now cap 62. The Parliament has now put in place regulation or a provision that inter-country adoptions shall only be a last resort, where say a child is orphaned, abandoned, legally relinquished, and is unable to access child welfare services within the context of Uganda for them to be allowed to be taken by someone out. This was not the case in the past. It is a last resort right now, which means that even locally our country is taking steps in light of the children's welfare to ensure that as a government, as a country, we are taking steps to care for our own children. It shouldn't be a practice that people are making money out of. You know, in the past, some practices on adoption very akin to trafficking or, you know, selling children away. I've dealt with cases where, I don't want to sound racist, but it's usually white people that come to adopt children. And, you know, rather than taking them on as their own children, these children are taken like some kind of labor or pawns to show that they are good people in a particular community, you know, for political reasons. Or recently someone shared one of politicians' children who passed away being pawned at a political rally for political mileage. That shouldn't be the case. Children should be protected. And what I've seen as an emerging issue, a key emerging issue, because there's many that I'm yet to hear from some of you in the practice, is the secrecy clause in our adoption guidelines. Clause 14 of those rules provides that all documents filed in the court shall be confidential and shall be kept secret by the registrar or chief magistrate. Understand that this is always made in the best interest of the child, you know, because issues of family can be emotional, but could also affect the child for the rest of their child. This practice or law, whereas is made in the best interest of the child, I find very archaic and harmful as well, because it aids trafficking. When the public does not know, you know, I like to believe, I strongly believe that in Africa, a child belongs to a community. When a child is born somewhere, we all know that that child comes from that place. So if this child, by some reason, is adopted, say, by someone outside this community, and we cannot monitor or see where this child has gone and how this person is dealing with this child, if we, the birth community, let me say community, are not involved, many things go wrong. So birth families with no legal knowledge of where to find the paperwork of the people that took this person, especially as most applications are done ex parte, without them necessity of requiring their presence in the court, even though the law requires that you serve them with notice of the proceedings when they are coming up. But, you know, I have argued in several platforms that the language of the court is not familiar to communities. Even if the community comes to court, I represent vulnerable women and girls in court all the time. And every day as I leave court, I am asked what happened. And they were there with me during the proceedings. Sometimes the clerk is interpreting what is happening, but the whole proceedings are alien to them. So if imagine a process which is ex parte, it is private, in the best interest of this child, but the birth family has no idea what is happening. It becomes difficult to trace the country of adoptive parents, to get updates on their children, even though I know that in the new amendment in 2016, the Children's Act, again, the law is requiring that these families who take children out of the country should report to Ugandan missions in their country on the welfare of these children. I'm not sure if anyone is monitoring this. I know that even with labor attaches who are adults, the government is having problems tracing them or receiving reports about their whereabouts. Now, imagine a child who has been taken by someone. And it's up to that person to report to the mission the costs involved are on that person. The government is not investing anything more. It becomes a whole risky venture. Our rules are outdated. You know, I mentioned they were made in 1997. More than 20 years later, we are still relying on that. And in the past 20 years, there's been an evolution in the legal field in so many ways. So some of the best practices I have read about, and which I believe even in my practice could work, a recommendation for us to adopt open adoption arrangements where a free flow of information is allowed between birth families and adoptive parents. If I have given up my child for adoption, I shouldn't be cut off forever. I know that even when we're talking about reproduction and surrogacy, we are now saying, okay, if I've been a surrogate, I've developed an attachment on the baby. Even after the biological parents take the baby, the information should be available. It should be the same in cases of adoption. Sometimes babies are adopted as babies, so once they are taken, unless the birth families are not interested, but in the Ugandan context, I know that most families are usually interested in knowing about the welfare of the child. The information should be available and free and open and easily accessible. We need to get rid of that secrecy clause. I know it's to protect the child, but if I need the information and maybe I can pay for it and access, the child can be located. Or if the child at one point grows and wants to locate their roots, they should be allowed to be able to do that. With the evolution of, again, technology, integration, AI lately, can we leverage digital platforms for adoption processes? For instance, online matching. I know so many families or friends who want to adopt children, but just the process of going to a children's home to look for a child that you will connect with. And you know, with the internet and technology, you can see these children, maybe even interact with them. For probation officers, even do visual home studies and supervision. I believe it can enhance efficiency and confidentiality at the same time if managed well. I also looked at child-centered approaches, prioritizing a child's needs and well-being throughout the adoption process. Many times as adults, especially in the African context, when we are giving away children, we do not even ask for their opinions. If they want to be given away, or if they want to choose a family, for those that are in children's homes, what kind of family am I going into? If Prima is the person that is adopting me, do I like Prima? The ethnic and cultural background of the person needs to be put into consideration throughout this adoption process, because socially, mentally, but also, you know, getting involved into a new community, a new environment should be something that should be monitored and incorporated into the adoption process. We also need to put in place very strong and efficient anti-trafficking measures. The government needs to invest more, aside from just writing, you know, anti-trafficking laws and, you know, criminal provisions that we put here that we cannot even transport outside the boundaries of our jurisdiction. We need to put in place monitoring mechanisms. I'll stop here to allow for interaction, questions, and comments if there are any. I thank you.
Thank you so much for that insightful discussion on adoption. You can see the emojis, hand claps coming through online. Clearly, people do appreciate. So thank you so much for that discussion. There's just a couple of questions that I would like to put to you, Prima. Maybe we'll start with, we've had instances in this country whereby post-adoption, parents do come up and say, I wasn't well informed about what the legal effects of this arrangement would be. My child was only going for, let's say, education, the return back. I had no idea I was giving up my rights as the parent. How can you ensure that biological parents fully understand the legal implications of adoption, especially in cases whereby they don't understand that this is not temporary placement, but is going to alter the rights of parentage? How can we ensure that it's a balanced discussion and parents are well informed?
Okay, thank you. I think I tried to respond to this in my presentation when I said we should have open adoption arrangements or guidelines, which allows for free flow of information in a language and mode that birth parents understand. And I know, I don't want to quote law firms or lawyers who have done this, but usually because for you you're targeting your legal fees, and there's this birth community, this adoptive community. In most cases, one be even coming to the whole process and system from a very desperate place. Maybe they don't have children of their own, and they are looking for an opportunity to adopt and also have a chance at experiencing parenthood. So then we start asking them for money, we pay money, and vulnerable women are looking at, I am willing to give the best that my child can have. But adoption orders are not absolute orders. They can be reversed if fraud was involved. If, lying or manipulating birth parents was involved, the adoption orders can be reversed. The law provides for a legal procedure on how to do that. But if there is free information and the birth parents understand, or birth guardians, the community understands that this child has no parent, they have no one that is caring for them, and there's this person that has come in place to give them the best that the world can offer, they will understand that it's not a temporary arrangement. If we want a temporary arrangement, we can work on guardianship letters where you can, co-share your child. There are different legal ways. But for adoption, it's permanent. The child is going to another family forever. So that information, I believe free flow of information between birth families and adoptive parents can help eliminate or mitigate some of those challenges.
Thank you so much, Prima. We don't have any other questions coming through, but maybe just to comment on a very interesting principle that you mentioned, allowing adopted children to be able to see their birth parents. Yeah. In fact, I think there's been jurisprudence in places like the UK, where maybe I should just quote, a judge in a case had said that there needs to be a sea change in that approach, because there are strong indications that face-to-face contact helps adoptees develop a sense of identity, to accept reasons why they were adopted, and also move on to their lives. It gives them closure. Obviously, for children, that's very helpful to their mental health, because people seek their identity, reconnect with their roots. So I think progressive countries have moved away from the no face-to-face contact and moved on to the aspect of children being able to meet their birth parents. So yeah, it's a best practice that we need to adopt here as well. So thank you very much, Prima, for your insightful discussion on adoption. I'm certain that there are no further questions, and people are satisfied with the presentation as is, and it's been a very insightful one. So thank you so much. I'm sure there are no other questions online. Just to be sure, let me check. Yes, there is a question here. Thank you, Prima. I'm aware that adoption alters parentage rights and transfers parental rights. How will this open adoption arrangement work? Don't adoptive parents have a right to enjoy the child exclusively, especially given the permanence of adoption orders?
Yeah, adoption is permanent, but we do adoption, and our parliament has put in place laws in the best interest of the child. As I read this question, I kept thinking about degrees of consanguinity. If I am adopted by an Acholi mother, I come from Busoga, and I move to Guru, I become an Acholi, I grow up an Acholi, and then I meet a Musoga man. You know, if I do not know that I'm a Musoga and perhaps could belong to that clan, I mean, problems for me and our children. So I think open adoption arrangements are not good, are not only good for the adopted child, but even for the parents, to allow the child to experience their origin, where they come from, their culture and ethnicity, and in the new international agreements that Uganda is signing on, the United Nations Convention on Rights of the Child, the African Charter on Children's Rights and Welfare, all seem to be pushing for open adoption agreements to allow children in these arrangements to know who they are, where they come from, and how they can interact. So parents do have a right, but at the end of the day, we are looking at the best interest of the child. And for many, unless the child doesn't want. That's why in the best practices, I also mentioned support services. Psychosocial support is very important as they go through this whole process. I know for many people in Uganda, when you adopt a child, there's a degree of secrecy. Everyone wants to adopt. Don't tell them that they are a child, you know, they're a child nonetheless, because if you say that you're adopted, then stigma and discrimination starts eroding you. But I think with awareness, this has to be done. It's also our job, duty of government, but maybe even as lawyers, as we're talking about adoption today, to make communities aware, not just among ourselves, but even out there, that, you know, adoption is permanent and final. The parent has rights, but so do children. And knowing where they come from is equally important and should be catered for. Thank you.
Thank you so much, Prima. We do have another question. Maybe I'll just read this comment from Mrs. Patricia Tim. She says, thanks, Mama Prima. Because biological parents consent to the adoption, knowing the consequences, why should open adoption be permitted for all cases? The adopter is duty bound to inform the child about the adoption to address other issues. We've taken note of that comment. Thank you so much. We do have one final question from Catherine. Aren't adoptive parents under obligation to inform their adopted child about their biological children once they attain 18 years? I think you've touched on this, but maybe you'd like to clarify.
But, there's no legal obligation that requires you to reveal all of that information. But helpful information when making a decision. But again, this is what I say, that because the whole process is ex parte, and again, the secrecy clause that all the documents and the processes are kept, you know, by the registrar and the magistrates, and the information is not open for people to be able to make inputs into it, also poses some questions of concern for us to address. So I've only offered a recommendation for open adoption to allow communities to engage and say, hey, Prima cannot take that child. She already has 15. I'm only doing this, and maybe the court might say, okay, maybe she's not the best mother in this case to do that. So if the process is open, it allows for dialogue and interaction, but also support services to this child who might not be having many people routing for them.
Okay, thank you so much for that response. Is there any other question? Did you? Okay, I think we're good now. So I'd like to thank all our presenters and participants for the first half of this panel discussion, for their rich insights that have been shared in that earlier session. We're now transitioning to a panel discussion on what's promising to be another insightful discussion. It's going to spark deep reflection on our current marriage bill. That session will be moderated by my co-moderator, Mr. Robert McKay, and I'm pleased to hand over to him to carry us through the next session. Mr. Robert McKay, are you online?
Yes, Phil.
Okay, thank you so much. I'm pleased to hand over to you, sir, to carry us through the next session. Thank you.
I intend to introduce the presenter, then later the panel discussants, so that we can set the ball rolling. Ladies and gentlemen, it's my great pleasure to introduce to you my former lecturer at the Lord Women Center academic year 2006-2007 in domestic relations. That was the subject by that time, Dr. Harriet Diana Musoke, Senior Counsel. Dr. Harriet Diana Musoke is the past president of the Uganda Law Society. That was 1998 to 2000. She is a distinguished academic, legal practitioner, and human rights advocate whose work has left a lasting imprint on Uganda's legal and social landscape. And as I have told you, I've been a beneficiary of her good works when she was heading domestic relations at the time. She served as a senior principal lecturer at the Lord Women Center. Of course, you know that is the country's premier postgraduate legal training institution in the country. And she is a senior lecturer at the Islamic University of India. Ladies and gentlemen, her teaching spans family law, human rights, women's rights, and health law, with particular focus on reproductive and sexual health rights. Dr. Musoke earned her LLB from Makerere University and LLM with distinction from Georgetown University in US, and a Doctor of Juridical Science SSJD from Emory University.
Maybe, Mr. McKay, if you could turn off your video, because maybe it's affecting the bandwidth.
Philip, am I still being?
Yep.
No, I have this band internet. think it's better there, right? Philip?
Yes, Mr. McKay, we can hear you loud and clear.
We had a problem with power. I beg pardon and my apologies. So I was rudely interrupted by the power outage. I was saying that her groundbreaking doctorate research explored how international reproductive and sexual rights can be adapted to reflect African realities, ensuring their meaningful exercise by all women on the continent. She has practiced the law, and she brings with us a deep expertise in family law, children's rights, and gender justice. She sits on several boards, because if I go through those boards, we may not have time, including the Uganda Registration Services Bureau and the editorial board of the Uganda Living Law Journal. She is a member of the Uganda Law Society, the Uganda Association of Women Lawyers, and the East African Society. With numerous academic publications and conference presentations to her name, she continues to be a leading voice in shaping legal education and advocacy around the rights of women and children. Ladies and gentlemen, please join me in warmly welcoming Dr. Harriet Diana Musoke to the platform to make a presentation on the marriage bill.
Thank you very much, Robert, for that introduction. Good morning, ladies and gentlemen. Good morning, colleagues that have joined us online for this CLE training. I'm sorry, I think I'm developing a code, so somehow you'll find that sometimes my voice may not be very audible, but I'll try as much as possible to see that we have this presentation. Now, my task today is to go through and point out some issues in regard to the marriage bill. And I believe most of you have had a chance of looking at the bill. And those that haven't had a chance to look at the bill, I'll just point out the various clauses that I think are changing or are trying to change the landscape of the marriage laws in Uganda. The marriage bill is bill number 73 of 2024, and its purpose mainly is to try and consolidate all the laws that are in relation to marriages recognized in Uganda. But when you look at the bill, and I think this is where we have to distinguish, it also talks about issues concerning grounds for divorce and what is going to happen when parties are divorcing. So I don't know whether it was because, as you remember, at first we had the marriage and divorce bill, and everybody said, how can you have marriage and divorce in the same legislation? But it appears, according to the bill, that they only removed the word divorce, and it still the aspects that were in the marriage and divorce bills are part of what we have here. So I'm just going to point out some issues which I think we need to really look at as we are looking at the bill. Now, when you look at, and I'm going to go clause by clause, when you look at in the interpretation section especially, and you look at the non-monetary contribution, the definition here that we are having is when you have contributed to the maintenance of the matrimonial property. So it is limiting now the non-monetary contribution to the maintenance of the matrimonial property. And I don't know whether this will also include looking after the children, making sure that the husband comes home and there's the warm is bed, the food is okay, or making sure that when the wife comes back home, the man is ready to emotionally help her out so that she's going to be able to do the work. So I think this is something we have to look at and see whether the interpretation we've been having in the various case laws, which include the consortium and the looking after the children, ironing the clothes and so on, whether it will be provided here. Then the bill also introduces something new, what we don't have, although in practice, many people still wonder whether prenuptial agreements can be enforceable in Uganda. And the argument has been that since we are members of the Commonwealth and prenuptial agreements are acceptable in the Commonwealth, then they should be applicable here. But then this bill now introduces even postnuptial agreements. And when you look at the definition, and this is where I got an issue and where we need to look at. And when it talks about the postnuptial agreement, it means an agreement made between parties to a marriage. Okay, they are married, and prenuptial made in parties to an intended marriage. Now, how are we going to have these postnuptial agreements enforced? We are living together, we have acquired this property. Maybe I'm thinking in the future that we are going to separate, and then I say, let's have a prenuptial agreement. Now, are these parties, will they be able to agree? What if they don't agree? Aren't we encouraging domestic violence? Because if I have property and I say, I think we are about to divorce, but let me have this property now in my names, and you agree that you are not going to benefit, isn't that going to cause problems? And secondly, is that not going to cause issues when we get to marriages, that people, when they get married, they will know that as we are working, and then at some point I will say, I want a postnuptial agreement. So this is something we really need to look at. Do we need it if we really want to preserve the institution of the marriage? And then another thing that I think we need to look at is where they talk about polygamous marriages and potentially polygamous. I think no marriage is, I don't know, marriages are potentially polygamous. So when you talk about a polygamous marriage, that a customary marriage is polygamous marriage, it is potentially polygamous. So I think this is something that we also have to look at and see whether we should use these words and whether they are okay. And then when we look at clause 4, which talks about the civil marriages. Now, civil marriages, we all know, those are the secular marriages. Those are the marriages, strictly you have to follow the law. And here, civil marriages are going to be considered potentially polygamous. And my question is, what mischief is being addressed here? Why do the parliamentarians want to have civil marriages to be potentially polygamous? Does it mean that this is now the government policy, that it's going to recognize polygamous marriages? Because if the government that is there, the law, depending on the law that the government have put there, and they are saying that they are potentially polygamous, I think, I don't know what mischief is being tried to bring up here. So that is one thing we really need to look at. Would you really want to have a civil marriage to be potentially polygamous? Now, when you look at clause 5, and clause 5 deals with deals with Christian marriages. Now, when you look at the Constitution, it provides that section, and I think it's Article 31. A man and a woman of the age of 18 are free to form a family and they can get married. And then you have in this particular clause that if you are going to get married under a Christian marriage, you must have the consent of the parents, and you have it. Now, and isn't this going to be contrary to what the Constitution provides? And when you talk about a parent, does parent include guardian? Because we are really having a problem in the practice when you're talking about a parent and a guardian. These have the same responsibility, but they're not the same. So how are we going to look at this, where people already are having issues that there are so many formalities to have the Christian marriages, and now we are adding on the other aspect of consent marriage. I mean the consent of the parents. I don't know whether this is something it should be done, or it is something that we should leave to the Christian faith, that they should have it but not put it in the law. And then when you also look at continuing with this, it provides that a marriage to be solemnized is in a public place of worship or in a place approved by the registrar. Now, this clearly shows from my reading, because it says solemnized by a licensed registrar in a public place. My reading of this is that we are trying to get away with licensing of places of worship. I think this is going to be very dangerous. Very dangerous in that if you're going to say that any public place of worship, what do you understand by a public place of worship? If I have my home and I have it as a public comes in and they worship from there, can weddings be conducted there? How are we going to be able to follow up what marriage has taken place or not? And I believe when they were having the Marriage Act, the purpose of saying that the place should be licensed was to ensure that they know where the marriage took place, and the marriage certificate can be very clear. Because now if I have my home in Lunguja and I allow people to come in and we pray, that means it's a public place of worship. Means I can also conduct marriages. Then you are going to have the makeshift churches or the makeshift places of worship. Today I have my place in Lunguja, and then I go to another place. How are we going to be able to trace and have a record on the marriages? So I think this is something we need to look at, and I think we should not remove the licensing of the places of worship. That should remain because it is important, especially when we have to look at matters concerning how we are going to follow up on issues of these marriages. Now, when we look at clause 6 on customary marriages, now it provides for giving notice. Now, who is the notice going to be given to? Is the notice going to be given to the place where the bride stays or the groom? Now, what if the marriage, because remember customary marriages, it's custom, marriages between families. Now, I am a Muganda, I'm getting married to this handsome Karamojong man. The Karamojong gentleman is coming to Uganda. So where am I giving the notice? Am I giving the notice in where me the bride, or am I giving the notice to where the groom comes from? So I think issues of custom, if we want to regulate them, and especially since customs are dependent on where the different tribes that we have, I think this is going to bring a very big issue where we bring about where we are going to have to be giving notice. Now, when you look at all these marriages, the customary, the Hindu and the Baha'i, they all give conditions. But of all the conditions, and as we've been knowing, one of the conditions is people should not be of the prohibited degree. Now, when you look at the bill, it is actually only the Hindu marriages that if persons are within prohibited degrees, that they cannot get married. Now, my question is, does this mean that it's not applicable to the other marriages? Because it is a danger when you provide that for one marriage and you don't say about the others, when it is clear that each marriage has been given its own clause. So I think that is also something that we need to look at and see whether it is going to be helpful enough. Now, when you look at, and my other concern was, when you look at the Baha'i marriage, it provides that if a marriage is to be considered a valid Baha'i marriage, these words must be mentioned. We will all verily abide by the will of God. Now, what if the Baha'i faith changes and now they are using other words? Will we have to amend? I think this should be left to, as all the others, that according to the observance of the churches of that particular faith, rather than trying to put this here, because then eventually, are we going to have I do in the Christian faith? Are we going to have, I don't know what happens to the other customs, how they are going to do that. So I think once we leave this out, it's going to bring it's bringing a lot of loopholes, and people may use these loopholes to try and go around the law. Now, when you look at clause 9 deals with Islamic marriages, and what the little that I know about Islamic marriages is that once the lady agrees on the mahari can be paid in future, but they can undergo the marriage. But when you look at clause 9 read together with schedule 4, one of the conditions to have a valid Islamic marriage is that the mahari must be paid before the marriage takes place. So isn't this going against the teachings of the Islamic faith? Now, what if the person says, okay, I'll give you the mahari after 6 months? Won't there be a valid Islamic marriage? So I think this is something that we also need to look at and consider. Now, Clause 10 deals with the issue of notice of intention to marry, and it is giving the powers to the Registrar General to do this. But we still have a problem in the definition section, where we have the Registrar General and then we have the Registrar General of Marriages. Is the Registrar General the same as the Registrar General of Marriages? Or should we have one Registrar General and then we can have Registrar of Marriages, such that we can be able to differentiate between these two? Because if we have Registrar General and then Registrar General of Marriage, I think outside there, people who don't understand the law very well, then we are going to have a problem with it. And I think giving the Registrar General powers to dispense with notice, well, I am not against the powers and the integrity of the office of the Registrar General, but I think giving these full powers to dispense with notice. Now, what if the marriage is going to take place in Moroto? Do we have to give, because we have one Registrar General, or will Registrar General also mean assistant registrars? So that is something that we also need to deal with. Now, when you look at clause 13, it talks about issues of time, 9 to 5, except for customary marriages. Now, what about the Islamic marriages? We all know that Islamic marriages can take place at home, and it can happen, the nikah can happen after 5. So is that going to make these marriages to be not valid? So this is the danger this we have to look at when we try to bring all the marriages together and we have them in one law, and yet they have different conditions. So that is something we need to deal with. And then in clause 15, it talks about compulsory premarital counseling. Now, they are going to make it compulsory. Before you get married, you must have counseling. Now, the issue is, how will you prove this? Do we need that after the premarital counseling, you must have a certificate? We all know that under customary laws, there is the premarital counseling, and it's done by the paternal aunt or the uncle and so on. So are they going to give in these certificates? Because if you're making it compulsory, in any case, in most instances, and in some, it has been compulsory. But how are we going to prove this? Will we need a certificate in order to prove it? Or are we just going to go by word of mouth? And I think this is already, people are already, those who want to get married already have issues and say there is a lot, so many conditions that are being put there. And now we want to introduce even another one. So we really need to think about this more carefully. Now, clause 16, which is which I found to be very, very, I don't know whether interesting or whether we have really, and this provides for marriage virtually, a Zoom marriage. You're in Uganda, you want to marry your husband from Japan, then you get on the Zoom, pam, and then the marriage takes place. Now, the issue of jurisdiction. Are we going to look at the jurisdiction of the groom or the jurisdiction? Because we are in different jurisdictions, that aspect. Now, we all know that reason why people get married is they are legalizing the sexual intercourse. That's the most important thing, why people get married, so that it is recognized. Now, how are you going to consummate this marriage? Are you going to consummate the marriage? The man is in Japan, Tokyo, and I'm here in Uganda, Kampala. Are we trying to get away this very important aspect of consummation, of sexual intercourse of a marriage? Is that what we are trying to do away with? And we really watering down the institution of the marriage? Because that is the purpose where we are having people having marriages. So I found this to be, I don't know, there must have been a reason why people thought it is important, but to me, I think from all that. Wherever you go, the reason why people get married is they want to legalize their sexual affair. And now, if you're going to say that you can get married, is it for company? I don't think you'll even have the company. If you're in Japan, I'm in Kampala, how are we going to do that? So I think this is a clause which as members, I don't know, those members who are on the family law division forum, what they always talk about the you know what I'm talking about people who are in that group. I think we really have to not have this issue of consummation be done away with, because if we are going to allow Zoom marriages, I think we are doomed with this kind of marriages. Now, clause 18, of course, talks about the licensing of places, and I've talked about that, in that I think it is important, and I don't understand what mischief are they trying to do away with, and they say a place of worship, it doesn't need to be registered. What mischief? So I think that is something that we need to deal with. Now, when you look at the section 20, clause 20, I mean, the registrar of marriage must attend a marriage ceremony. Now, when we are talking about a registrar of marriage, we are looking at all the marriages. Now, here the most important one is that one of the customary marriages. When we are having customary marriages, why are you forcing the registrar of marriages, who is, I think, in this case, the sub-county chief, why must that person attend the marriage? Now, what if in that sub-county there are 3-4 customary marriages taking place? What is going to happen? We know that in some of our customs, bride price or whatever, the negotiations take place at midnight, 1 a.m., 2 a.m. Are you going to force the registrar to attend the customary marriage? Because the customary marriage, what we have is, what is important is this payment of bride price, and then the parents of the bride will give away the girl. So how are we going to have all this done? So I think this is going to be very cumbersome. And not only that, who is going to incur this cost of bringing in the registrar, the marriages, deep down in the village somewhere, and you're going to have this marriage, but the registrar might attend. What if the registrar is not able to attend? Will that mean that the marriage is not valid? So I think we need to also need to look at that particular aspect. Now, another interesting aspect of this law is clause 21, marriage in Ugandan embassies, high commissions, or consulates. Now, a marriage may be conducted in a Ugandan embassy. Who is going to conduct this marriage? Are we going to designate and license somebody at our embassies to be a registrar of marriages? Now, if they are going to give the notice of marriage, and remember, one of the issues here is that one of the marriage must show that there is no impediment to the marriage. Okay, I'm here in Uganda. I had my husband went for commonly with the common word cheyo. He's in the US, and then while in the US he finds somebody, and then he gives a notice to the embassy. Now, of course, I will not be able to get that notice, so it means I cannot be able to caveat. So it means the marriage is going to take place, and we're really burdening the embassies. Embassies, their purpose is for political issues, are for administrative matters. Why are we bringing them in to start conducting marriages? And then at the end of the day, they will say, well, this person gave us notice and said there is no impediment, but now I get to learn about it, and then I want that marriage to be declared a nullity. I think we have yes, we want people to get married, but I think we are stretching it too far, and by stretching it too far, we are going to have problems on how we are going to regulate this issue of marriages. So that is something that I think we also need to look at, and I think we should not be something that we should look at. When you look at clause 22, it talks about a certificate. And it talks about monogamous marriages. Now, is it going to only be applicable to monogamous marriages? What about the polygamous marriages? Are we now trying to differentiate between the polygamous and the monogamous, and then the potentially polygamous? So Is a monogamous marriage potentially polygamous marriage? I think all these words, when you use them, trying to use them, I think they are going to be a very big problem, especially to our colleagues who really don't understand clearly the law, or even us as the lawyers. Because when I talk about a marriage being polygamous and one being potentially polygamous, what is the difference? Okay, so that is something that we need to deal with. Now, when you look at Clause 23 and 24 and 25, they all talk about the objection. If somebody wants to object to a marriage taking place, you have to send it to the Registrar General. Now, the Registrar General, for example, sits in Kampala. I have given my notice of marriage to which St. Stephen's, All Saints Church in Zimbabwe. Now, the Registrar General will get the notice. What about deep down in Zimbabwe? What is going to happen? Will it be the registrar then to give the notice? Why should we remove the notice being given to where, I mean the objection being filed with where the notice has been given? This, I think, is going to create many people giving notices to different places, and it's going to be very difficult for them to be followed up. And I think we are burdening the Office of the Registrar General when they already have a lot on their plate. Now, when you look at, and I'm leaving out some of the clauses, but I'm looking at those clauses which I think we really need to reflect on more importantly, and we see whether it is helping to strengthen the institution of the marriage. It is helping out for people to stay married, because people stay married whenever an issue, for the many years I've handled, the issue rotates about sexual intercourse. Are we trying to remove the issue of sexual intercourse and consummation from the marriage? So that's why I'm just looking at some of these clauses and leaving out others, and we can have a conversation. Now, when you look at Clause 39, and this deals with converting of marriages, that a marriage contract under this Act may be converted from monogamous to potentially polygamous, or from potentially polygamous to monogamous, if the husband has only one wife, by a declaration made by the husband and the wife that they each, of their own free will, agree to the conversion. Ladies and gentlemen, we know, we know it, we are all adults. This free will that I want to convert now the marriage, and I've given my free will, we know there is no free will that will be given. And secondly, I always ask myself, what was the rationale of converting a monogamous marriage to a potentially polygamous marriage? And here they're talking about a marriage contracted under this Act, meaning a civil marriage, a church marriage, a Baha'i marriage, a Hindu marriage, an Islamic marriage. Now, isn't this going against the faith of these churches that say Christian, Baha'i, and Hindu, one man, one woman? Aren't we overlapping on what they're doing? So I think we also need to look at that. And most importantly, I want to understand, what was the rationale of converting? Is it that because from the reading of the Act it appears the government is going away from earlier what was considered to be an ideal family, one man, one woman. Now it is one man, many women. So it appears that is what is coming up, and maybe we need to have a rationale over this, and we can clearly be able to understand it. Now, when you look at Clause 40, and this one is on void marriages, there is this new word which I had never read, and the truth is I can't even pronounce it. When you look at Clause 41, F, a party suffers from permanent impotence or vaginismus, and the fact is not known to the other party at the time of contracting the marriage, then that marriage is void. Okay, now, what is this word, vaginismus? Whatever that word is. Now, this is becoming an issue. So now, if with the issue of potentially permanently impotent, that one I think medically can be proved, and that's why when we look at the old act, it says you have the medical practitioners and they prove it. Now, how are they going to prove this? Whatever this word, ladies and gentlemen, sorry, but I can't. Reading it is, but you can be able to read it. So that becomes an issue, and we have to see how are we going to look at that particular aspect. Because if a man comes up and says the woman has this vagina, whatever, is that going to make it then avoid marriage? And isn't that going to make it even easier for people who want to run away from the marriage? Excuse me, who want to run away from the marriages, saying that my wife has this issue and then I want to get on another marriage. So that is something that we have to look at. And then when you look at clause 41, and clause 41 is on voidable marriages. And it says, a marriage is voidable where one of the parties to the marriage is unable to consummate the marriage within 6 months of celebrating the marriage. Ladies and gentlemen, from what I know, marriage is legalizing sexual intercourse. And then you tell somebody, wait for 6 months, let's stay there as brother and sister, and then after 6 months, then you are going to apply and say my marriage is voidable. Is that really a long time? I remember when I was pursuing my PhD and I was in Atlanta, the issue came up and said, when are you going to know that a person has failed to consummate a marriage? And some states were talking about it should be 2 days, 3 days. If you love this person and you've gotten married, why can't you consummate the marriage? Now here they're waiting for 6 months. You cannot able to consummate. That's when now. What is going to happen within these 6 months? Somebody's waiting. I married you. Why did I marry you? I married you because I want to have regular sex morning, evening, afternoon, wherever, bathroom, sitting room. And then after you tell me, wait for 6 months, isn't this a ground where we are going to have a lot of domestic violence? Isn't this an issue where we are going to have many people fighting? And then eventually we are going to have people saying that I was forced into sex and so on. So I think that 6 months is really such a long time to say that it is after 6 months that you can be able to apply that the marriage be declared voidable. I think the period is unnecessarily too long, and something has to be done. Now, when you get then to part. When you get to part 4, and that is all these other types of marriage properties, I think those we can discuss them, but I want us to look at part 4 that deals with matrimonial rights and matrimonial obligations. Now, when they're talking about consortium, they're dealing with consortium, and it's provided for that during the subsistence of the marriage, people have rights and obligations commensurate with their marriage status. Now, what is commensurate with the marriage status? Okay, and this is you have to look at the interpretation section, and according to interpretation section, when you look at what is meant by consummation, it means the benefits a spouse is entitled to receive from his or her partner, and includes the fact of a husband and wife living together, the mutual rights to sex, companionship, comfort, affection, care, and all rights and obligations commensurate with the marriage status. And what are these rights? I think they are going to be then left to the interpretation of the parties, and this might also bring another problem when we are looking with these issues. Excuse me. Okay, thank you very much. I'm sorry about that. Now, our clause 47, of course, it deals with the issues of postnuptial agreements, and that's why I was saying this issue of postnuptial agreements, I think is going to cause a problem. And clause 52 deals with contribution to property acquired before and during the marriage. Now, we all know as people who have been in the practice of law that we are really having an issue of ancestral property and inherited property, which I believe these two are different, ancestral property and inherited property. So we need to understand here when they talk about property that has been inherited and then ancestral property and has not been defined. I think we need more clarity on this so that we stop getting issues when people are divorcing and we start getting problems. Now, clause 55 is another interesting aspect, the debt of a spouse incurred during marriage. You are married and you incur a debt, and then you are liable for the debt of your spouse. Why should I incur the debt of my spouse? We agree, we get money. When we get money, we get a debt. And then spouse uses money to marry another husband or to marry another wife. Now, why should I be made liable? Why should I be made liable for that debt? I think that is being very, very unfair to this other couple, this other spouse that did not participate in the use of the money that was being brought up. So I think this is all that something that we need to deal with. Now, when you look at clause 59, that deals with the distribution of property. With all due respect, this clause is very confusing. It's a mouthful, and it is really something that we really have to look at, because in all matters concerning parties, the biggest issue is about the distribution of the property. And now, what do you understand by matrimonial home and matrimonial property? And who is an immediate family member? So this is something that we have to look at. And then when we look at matrimonial contribution, I think it cannot be equated to non-monetary contribution. When you look at clause 59.4, the non-monetary contribution shall not be proved in monetary terms. So I think this is something we need to look at. Now, when you look at clause 61, my time is running out. So when you look at clause 61, yeah. Okay, thank you very much. This presumption of marriage, there is a presumption of marriage in relation to property rights. But then when you look at the offenses, it is an offense when you call yourself Mrs. somebody, or that is my wife, when you are not married. I think these are double standards. When we are living together, it is an offense. When it comes to issue of property, then you say that there is a presumption of marriage. I think we should not presume marriages for one aspect and we leave it to the others. People are either married or they are not married. And I think this was something that was brought in to help out with those people who are cohabitees, where it is a good thing, they may be provided for, but I think simply bringing it up and saying, when you presume to be married, you have committed an offense, and the imprisonment, my friends, is 5 years in prison because I have said I am Mrs. somebody and he didn't marry me. But then when it comes to property rights, then I'm entitled to property. When you look at, and I'm not going to go through them, but you can look at clause 61.5, clause 71b, clause 73 and 74, which is doing away with the grounds for divorce. And now this bill is introducing no fault divorce. Is this what we want in Uganda? And then when we look before, that parties can agree that let us petition. Let us agree to go to court, and they agree, let us petition, and both of them bring a petition. Is this what we want? What is the rationale that this law is trying to bring out? And then when we look at clause 77 on the cooling period, I think the rationale of the 6 months, I think that is also something we need to look at. And I think also look at clause 89 on holding out, and clause 102 and clause 103. Yes, there are many other clauses, but because of the time, these are issues that I think we need to look at and see, because the marriage bill, yes, we need to have the marriage laws amended, but is this the best way? And in my opinion, I think because you cannot get married under two different legislations. So in my opinion, I think we should look at each law separately, because each marriage has a uniqueness, and then we amend each law as is, and then we can be able to have this. Otherwise, if we bundle them up together, I think that's where we are having issues of one saying this and the other saying that. Thank you very much, members. I'm sorry I rushed you through this, but my time, moderator told me, was up. Thank you very much for listening to me.
Thanks, Dr. Diana Musoke, for the great presentation. Indeed, you have posed so many questions about the bill that requires serious interrogation for possible answers. You have also alerted us that we may need to rethink most of the sections in the bill for a possible solution. What mischief are the components of the bill trying to cure? Ladies and gentlemen, to answer most of these questions, the Senior Counsel will be joined by our senior colleagues in the panel discussion about legal harmonization and ethical implications about the bill. Please, ladies and gentlemen, welcome Miss Indiko Innocent. Miss Indiko Innocent, Mrs., is a seasoned advocate of the High Court of Uganda with nearly 25 years of legal practice. She brings to this panel a wealth of experience and a deep and unwavering commitment to family law. As the managing partner at Ngovi Indiko Advocates, she holds a Bachelor's of Laws from Makerere University, a diploma in legal practice from the Law Development Center, and a Master of Laws in Oil and Gas from Uganda Christian University. Her voice today adds practical frontline insight into the evolving field of family law. Let's welcome her to the panel. Next to her, who will join us online, is my brother Robert Ali Bogere. He's a senior state attorney with the Ministry of Justice and Constitutional Affairs with over 16 years of experience. He was the lead focal person in the Succession Law Task Force. He is an external examiner at the Law Development Center and volunteers to present classes on succession practice at Makerere University, IU, and many others. He loves sharing knowledge. He's considered one of the leading, if not the leading expert on succession law practice. Those of you who are on the family law forum for the High Court Division, you have seen him, how he articulates issues regarding family law practice. Now, let's set the ball rolling. I'll begin with Senior Counsel Diana Musoke. How does the bill aim to strike a balance in recognizing different forms of marriage, particularly concerning polygamy practiced within a certain religious or customary setting? I know you have touched more on those points, but we want to hear again from you. In the context of divorce, under Section 27 of the Divorce Act, we see that courts currently have wide discretion to vary prenatal agreements. With the proposed marriage, will courts now have less discretion to override such agreements? What level of sanctity or legal weight does the bill give to prenatal agreements? Won't the definition of holding out although married in clause 8 and 9 lead to arbitrary interpretation and potentially targeting cohabiting couples rather than its intended purpose? We want to hear from you on that if I go to the next panel. Over to you, Senior Counsel.
Second one on the prenuptial agreements. You find that actually some judicial officers are still very skeptical about looking at prenuptial agreements. Actually, some of them say that they are not enforceable in Uganda. Others say they are enforceable because it's an agreement, and if it's an agreement, the parties agreed, then it should be enforceable. And in most instances, those judicial officers that rule and say that they're enforceable, they will usually look at the terms of the agreement, unless if one of the parties says that by the time we entered into this prenuptial agreement, there was some misrepresentation. Maybe this person told me something that was non-existent, and so on and so forth. And that's when the court will now look at this issue of the prenuptial agreements. But otherwise, some courts just said, don't even talk about prenuptial agreements. They are not enforceable in Uganda. But others do. And those that do, if a party comes up and brings in an exception, that's when the court will now look at the prenuptial agreement and then look at the provisions of that agreement and see whether it was entered into freely. And that word free consent is the catchword. But was there really free consent? Now, I am 35, I'm coming to 40. I really want to get married. Everybody's saying, why don't I get married? I find this rich gentleman says, I want to marry you, but let's enter into this prenuptial agreement. Of course, I'm not entering it because but I want to get married because that everybody knows that I am married. So where is the free will? So that is one aspect that we look at prenuptial agreements, and many judicial officers have been consulting and wondering, can they be enforced? Where my problem maybe will come in is when we have the post-nuptial agreements. That I think is where we will have a problem, because it's something that has not been in practice. At least I've not encountered. I don't know whether there is anybody who has encountered any of this, but for the post-nuptial, I have not encountered any aspect about this. Now, when we look at the bill about the sanctity of marriage and bringing out polygamous and so on, my opinion is that if the faith, according to the faith, whatever faith, because it's the faith which provides that the marriage should be polygamous, let it be potentially polygamous. Those faiths that provide that their marriage is one man, one woman, then let that be one man, one woman. Now, when we get to having civil marriages, the government, because now by this, it clearly shows that the policy of the government is that polygamous marriages or potentially polygamous marriages are preferred. Before, as Robert said, we were rudely interrupted by the internet. I was just talking about it is good that we need to have our marriage laws amended, because I mean they are before 1930 something laws. It is important, but I think bungling them up in one legislation is not going to be useful. Why? Because much as all the marriages, the only common thing about all these marriages is that all of them are legalizing sexual intercourse, okay? And it is very important. All of them recognize the importance of sex in a marriage. But then they also, the way we get into these marriages is different. And if we try to put everything together, that's where we are going to miss out on some aspects. Just like you see here, all other marriages, prohibited degrees does not affect them. It's only we look at each law separately and then we make the amendment separately, and in that way we are going to put in more effort in that law and amend that law in accordance to what they have, because putting things together is different. Some countries, I believe like Rwanda, the only recognized type of marriage are civil marriages. You can go all these others, but it's civil marriages. So that one, that at least for them, they are very clear. But if we are going to continue recognizing all these other different types of marriages, then I think the best way to do all this is let's look at each one separately. And once we look at each one separately, then we are not going to have all these issues that come up with the aspect of the marriage bill. Thank you very much.
Thank you, Senior Counsel.
Yeah.
Against us.
Okay.
For gender balance purposes, I'll go to Mr. Bogere Ali. Mr. Bogere, how can lawyers effectively advise their clients on documenting and presenting evidence before producing to matrimonial property during legal proceedings to achieve fair outcomes? What are your general thoughts on the proposed marriage bill and the direction it seems to be taking in terms of regulating marriage and divorce in Uganda? Over to you.
Our colleague, senior crown, I don't know, I'm having an echo.
You need to raise your voice.
Recording in progress.
I see that in clause 3G, the minister has granted powers to recognize other types of marriage. Are they from Uganda or from abroad? Then 5B, clause 5B defines a Christian marriage as a union contracted between one man and one woman for life. This, even for Christianity, is not true. It's not true that all Christians are monogamous. It's a simple Google search will show you that amongst the Latter-day Saints and even other African Christian denominations, polygamy is allowed. There is a good case of a South African Christian, I don't know whether it was a pastor or something, who said, how can my church allow gay marriage and then forbid polygamy? So if he said polygamy is in the Bible, gay marriage is not. So you can't have a law which tries to put people in a box and then generalize it. So we should leave some things to the faiths themselves to handle. There is a notice of intention to marry in clause 10. If marriages are potentially polygamous, for instance, I'm conducting a polygamous a Muslim marriage, which is potentially polygamous, or a customary marriage, and I'm going to conduct one, it's my first marriage, why would I have to issue a notice to another person? Or if it's my second marriage actually also, why would I have to issue a notice in a marriage which is polygamous already in nature? When you look at clauses 32.1 and 32.9, they seem to infer that registrars will appoint other persons or to officiate marriages, which these other celebrants are, we are not told. Clause 38 provides that non-registration of marriages should not make them null. Now, this is 2025. We can agree that for the laws like the Customary Marriages Registration Act and the Marriage and Divorce of Mohammedans Act, those were years ago. But in 2025, where everything seems like years, and I've asked a widow, were you married, a woman? And she said, yes. I said, bring me proof of marriage. And she brought me a photo of herself and the deceased standing near a cow. That is proof of marriage. Other women have brought photographs of Kuchala, knowing that they are Kuchala celebrations, these past visits, and pretended that they were introduction ceremonies. There is another case where a lady asked me that, how are people married? I said, how were you married? By the deceased. And she said, how are they married? And I told her marriage in Uganda is conducted either customarily. She said, can my father write it for me the letter now? And indeed, I thought it was a joke. The father wrote the letter and backdated it. So we should have a situation in this country where marriages are registered. We don't need to have these things anymore. Now, senior counsel talked about this thing of holding out. Why would you say that people who are cohabiting are going to end up in prison? I like to be bold. We would have Moses Chigongo and Olive Chigongo in prison because they have been living together. Actually, they fulfill all the requirements of clause 39. They are living together as husband and wife. They acquired own property jointly. They had children, and they took the woman took the man's surname. That is something where we shouldn't go. I don't know why we want to legislate on morality. When you go away from ordinary persons in the army, for instance, soldiers are allowed to have women in every station they are deployed, and those women actually are allowed even to share in their estates without being in any recognizable marriage we have now. Are you going to go and arrest those soldiers from those barracks? Or are we going to have this law enforced only against the poor? Then this issue of consummation within 6 months. I don't believe that in 2025, this country, we seem to be very excitable whenever issues of sexual intercourse are concerned. I cannot understand why, if I am 8 years old, I cannot marry an 8-year-old woman. And no one should be concerned whether we are going to have sex or not. Those issues which are very private to do with whether marriages were consummated or not should be left to the parties when, for instance, they are going to divorce, not to be put there in our law. Let there be a general reason for that. Another issue of this, wives retaining the names of their husbands.
We are against time.
Yes, wives retaining the names of their husbands. And being forbidden to retain the names of their husbands. What is in a name? If a woman has already got her national ID with your name, titles with your name, wills, she has made trusts, passports, and you want to force her to uphold all those things because of an issue of your names. Finally, matrimonial property. The definitions of matrimonial property is very terrible. I think my final conclusion is that this bill should be withdrawn and thrown away, and something better be put on board. A matrimonial home may be, I have apartments where I'm occupying 1 unit. Is that assigned to me? What's then the matrimonial home in that aspect? What you are going to share? Then, something I've also shared, agreements are enforceable, the letter in the USA, but in the UK, which we follow mostly because of our history, they are not upheld strongly because the courts look at them and see whether it's fair or not. In the US, as long as you have shared, you have done it. Now, finally, on the issue of sharing of evidence you can bring to your cases for your clients when they are involved in matters of litigation around this area. Of course, it's very difficult. You don't start out in marriage with the preposition that the marriage is going to end. But when you look at Rwalimumi, it says that it is very difficult to determine what parliament because it says there is none. So it cited the case of Mutembwa versus Mutembwa, where court held that where the wife has made contribution to the acquisition of the property, and there was that contribution is a question of fact, and where it is impracticable to take account of for the purposes of determining the respective contributions of the parties to the management of the home, there arose a rebuttable presumption of equal contribution. So for me, I would start from there and saying, if your client has been married and she is the contributing party, she's not the party whose name is on the title. If she has been in marriage for 30 years, surely we're not going to get all the receipts. We're not going to get all the time she has looked after the children. So start from that strength of this case and say, my lord, or your worship, there is a presumption of equal distribution in the absence of evidence that my wife has, my spouse, my client has contributed this much. So you then go and prove that over all those years, this is what you have been doing. Otherwise, you won't have the receipts, you won't have the shops where you bought merchandise from, they are all maybe left the place. Thank you very much.
Thank you, Robert. I know this is a very sticky topic. It needs a lot of time. Maybe Uganda will need to organize a whole day, but we need to get moving. Now, my senior colleague, Innocent, could a simplified mutual consent divorce process undermine the institution of marriage, or does it provide necessary relief to struggling couples? Over to you.
I'll talk about this bill of 2024. Yes, it does introduce that. I don't know why. Okay. This bill introduces the issue of mutual consent for parties to divorce. In my opinion, the mutual consent for parties to divorce will, personally, I feel it will be good because there will be no acrimony if the parties agree to divorce. That's my personal opinion. It gives a healthy relationship between the parties if they do it by agreement. Right now, the courts are doing the same. However, there must be a ground that must be proved. Personally, I have no problem with that mutual consent to divorce. If the parties are tired of each other and they feel there's no future in their marriage, that's all I can say.
Thank you, Syria. This one again goes to both you, Innocent, and Mr. Bogere. In practical terms, what concrete legal standards does the bill provide to Ugandan courts for assessing and assigning value to non-financial contributions to a marriage? I know Robert has already alluded to that you can't go on looking for receipts. I've been looking after the children, you can't quantify that. Such as homemaking and childcare to ensure equitable distribution of matrimonial property upon divorce. Secondly, Section 44(2) of the bill prohibits DNA testing for a child born during marriage without a court order. While this aims to protect the child's privacy and dignity, it raises serious practical concerns around access, cost, and delay, especially for we the Wananchis, the ordinary Ugandans. Do you think this provision strikes the right balance between the rights of the child and the rights of a parent to abstain biological parentage? Lastly, Section 15B of the marriage bill makes pre-marital counseling a mandatory requirement before a marriage can be celebrated. While counseling is undoubtedly valuable, do you think making it a legal precondition places unnecessary barrier on the rights of consenting adults to marry? In your view, should counseling be encouraged rather than enforced? Any of you can pick it up in the next 5 minutes.
Can I start?
Yes, please do.
On the whether the bill gives any guidance on these contributions. First of all, I am not a believer in tagging the spouse, the contributing in quotes spouse share to contribution. I do believe that a spouse should be given a share in the law like we do in succession. Flat share. Now, other people who are not spouses, for instance, cohabiting women, would be the ones maybe required to cohabiting persons would be the ones required maybe to prove contribution. But if you were to say, let me give it if I have a 1 billion shilling house and I pay the security and at home I buy the food, I'm giving a general idea of let me say the reasonable man. You buy the food, you pay the school fees for being a man. You pay the school fees, you pay even the money for the maid. Now, your spouse will be maybe the supervisor, but in effect, you are the one who is washing the clothes, you are the one who is cooking the food, you are the one who is providing the security. So, the contribution of the man himself doesn't end at bringing the property. His contribution also can be non-monetary in terms of the money pays to do the non-monetary things. So you would end up with a spouse who doesn't get anything like that lady who got mark, just bed sheets. Let us give a spouse a flat share like we do in succession matters. Thank you.
Thank you, Senior Counsel. What is your take? Then I'll go to Innocent.
Start, Robert. Robert, I'll talk about the issue. I'll start with the issue of counseling, the mandatory counseling, which the bill is introducing. Personally, I don't think counseling should be legislated in the bill. Personally, I've been married for 31 years. I didn't attend marital counseling, and here I am. Secondly, this marital counseling making it mandatory counselors are paid for. This is going to create an unnecessary cost on parties that intend to get married. I personally disagree with the issue of making marital counseling mandatory under the law. Then the issue of the DNA test. I disagree with section 44, which says that any child born within marriage will be presumed to be a biological child. That is not right, because there are children born within marriage who are not children of the man in that marriage. So presuming them being married is not good. And also saying that there must be a court order for DNA tests to be done. I disagree with that, because it brings more litigation cases in the courts, which courts already have backlog, and also it creates unnecessary expense. People to pay lawyers to get court orders for DNA tests. If parties can agree to a DNA test, there is no need to have a court order. Maybe court orders will only arise where there is a disagreement. So that is my opinion. But there's no need to say that there must be a court order for DNA test to be done. That's all I have to say.
Thank you, Senior Counsel. In 1 minute.
On the DNA issue, I wonder whether this would apply to adults as well. We need a DNA law in the country, because it's an issue also in succession, where 40-year-old people are being compelled to do DNA by their young brothers who are 20, who found them already with their father. Now, then when you ask people, which law are you taking your brothers to do DNA, they talk about Children's Act. Children's Act doesn't apply to people who are over 18. So we need a law so that we don't have piecemeal DNA provisions in different laws. We don't need to have this in this law. We don't need this bill, actually. We need this bill thrown away, and and the government comes up with a serious bill. This bill is really terrible. Thank you very much.
Thank you, Bogere. You are part of government, you are part of us, so you'll advise them better. Now, to our colleagues online, there is Solome Awidi. She thanks all the presenters for your overview of the marriage. She submits that there is a lot of discussion on polygamous and potentially polygamous marriages, given the equality enshrined in our Constitution. Shouldn't polyandry also be considered? That's the question she's posing. Then she also submits that while we may question the rationale behind these clauses, we may also want to look into or consider the opportunities that the bill seeks to bring on the table. And for the parties in the marriage. Then my senior, this is grateful to Dr. Diana for the presentation. Right, ladies and gentlemen, it is time for Q&A. I know it is lunchtime, but we shall make it a little bit faster. We encourage you to post your questions in the Q&A chat room so that the presenters can be able to attend to you. And we are going to give it max 10 minutes. Patricia, I think the presumption of children in marriage is good. If issues arise, then DNA test can be done to resolve the question of actual parents. Otherwise, thank you. Barbara Kitui, thanks to Miss Innocent and Mr. Ali for the presentation. I'm yet to see questions. Philip, if you see them, you also alert me. Catherine, yes. If marriage bill is provided for polygamy as defined in its interpretation section, and also provision, just a minute, and also making provision for conversion of a monogamous marriage to a polygamous one, shouldn't it also specifically provide for polyandry? I think the presenters, you may need to answer that. Let me see if there is any other. Right, I don't see any other question. Any of you, either Robert or Innocent,
Okay, let me start
deal with what Catherine has raised.
I want to see one of the proponents of polyandry when she is the one who wants to be polyandrous, not to just throw it out there that there are women there who want to marry more than one. Let them show us those women, instead of us thinking that it is hip or it is we are doing something. Uganda is not going to be the first country where a woman even countries where we can see where they have gone to extremes of things we can't do. There are places in the US where you can, sorry to say this, where you can have workers sleep with an animal and it's not illegal. You can sell sex in the streets in some areas of the Netherlands. We can't do it here. Now, even in those countries, you can't have a legalized polyandry. There is issues which come to do with issues of children, who will take care of the children, when you die, who is going to share in your estate, which is when you are divorced. All those issues come in. Now, I do believe that we should be serious in some of these proposals and not just say them for the sake. Thank you.
Before you go off, Robert,
Yes.
our team is asking you specifically. Please note that the bill has progressive provision. The family justice terrain needs new laws that address the contemporary needs. So please embrace the efforts in place. since domestic relations bill to the various versions of the marriage bill to date. So that one is giving you a word of caution.
LGBT
You may
will
not
tell
need
you-
to answer that one, Robert, but let me go to the other question.
LGBT will
Proceed.
tell you that it is not progressive.
Robert, I'm the one with the mic, so you wait for the question. Prosi is asking, where is Prosi? She raised, yes. How will the bill address the issue of women who spend a lot of years with men giving birth to children only to be kicked out later with nothing just because he's not legally married? Robert and Innocent address that one in a minute. I'll begin with Innocent.
Can go first.
When I read the bill, it doesn't address cohabitees at all. So there is no provision to help women who are in cohabitation. It only deals with those who are married.
And just in addition,
Who have been with these men for so many years, with the children, then you kick them out.
thank you very much. That is a very unfortunate situation, because when you look at the marriage bill, it's about marriage, and unless we recognize cohabitees as being married, then they cannot be covered by this. And I can understand it is a tricky situation, but I think we need to find a way. Either when we are amending our laws in we can put it in partnership law or in contract law or whatever, but I don't think we can be able to address it in the marriage bill, because by living together, having children, and spending all their youthful years together, that does not mean that they are married. Only if we put in a clause that even people who have lived together for these years are presumed to be married. If it is not a presumption, then we can't have it. And when you look, and that's one thing we talked about, it makes cohabitation actually an offense. Living together and calling yourself Mrs. somebody when you are not, it's an offense. Although when it gets to property distribution, that is when it presumes marriage. And that's where we're commenting and said, if you want to have people presume a marriage, presume it, don't make it an offense. Have people share the property if you want, and then see how it can be dealt with. But in order not to bog down the bill, because if you start bringing in cohabitation in the marriage bill, you are definitely going to have a lot of resistance from the faith people. I think the best we do is let us have a separate bill, which we can deal with for people who are owning property, who have been living together, and then when they come to going their separate ways, how do we deal with that matter? Just like I think in the UK, when we had the Divorce Act, and later they had the Married Women's Property Act, clearly to show that even married women can be able to own property. So I think the only way we can cure this, if we don't want to bog down the amendment in the bills, is to propose another law where we are going to be able to deal with such situations where this has happened. And I think we shouldn't only look at women who have spent years with men and then they are kicked out. Currently, it is the women who are kicking out the men from their homes. Okay, so it is now not going to be when the man has been there for the woman has acquired a lot of money, tells the man, we are not married, move out, and the man goes out with nothing. So we should look at it in two ways. Not only women are affected, but also men are affected, and we need to deal with that, because most people are actually in cohabitation relationships. Now, Robert, I just want to say something about this issue of presumption of parentage of clause 44. My issue around this was when you presume that a child born is the biological child of the parties to the marriage. I've had cases where we've had issues where a gentleman goes, they married to the woman, goes bring in children. After they bring in children, when the woman tries to protest, they say the presumption of parentage of the child. You are married, it's presumed that this child is yours. I think we need to, yes, it will be presumed, but I didn't carry this child for 9 months. So why are you presuming that it's the child of the marriage? And I have seen in my practice, we've had so many issues that have come up where these children coming and say, we are married, we are presumed children of the marriage. We need the same entitlement. well, they need the same entitlement like the other children, but when they look at the side of the women, and it has caused a lot of rift, and we need to see how we are going to deal with this issue of the presumption of the biological child of the parties to the marriage. Thank you very much.
Thank you, Senior Counsel, and all the panelists. Robert, you wanted to add something?
Yes, something small.
Okay, please, in a minute.
Section 61, I think, talks about cohabitation for purposes of property, and yet Section 89 makes it a criminal offense. 89(2), you are in prison for 3 years for cohabitation. So you can't have both, and then after being sent to prison, then court determines your property rights under Section 61 and gives you property. So this thing is not good, and I think we should do it away with and come back with something better. Thank you.
I'm losing your network. I don't know whether it's mine, but
Yes,
I have a proper network.
I said thank you.
Okay. We have one from my senior Zik Namutebi. I had the opportunity of being mentored by her, Nyans Chiboneka, and she's saying, even if having cohabitation legalized in the marriage bill, are there equivalent protection provisions in the succession law? Paul Henry, how practical would this one be? Those ladies who are looking for it. Whose wife are you? And at what point? When do you determine child X belongs spouse B and not Z? And she's grateful to Senior Innocent and the brother Ali. And I think this one goes to you, Ali. You may need to pose this question about these ones who are saying that if you are talking about equality, let it be. Also allow me to have more than one man. Why should a man only have more than one woman? What is your take? Because time is against us, Robert.
We are going to go into, if we are very progressive, why are we forbidding gay marriage? Some things are not done.
Say that again.
I was saying that we are going to go into an area where people will ask that if we are very progressive, why don't we allow gay marriage? So there are some things which are not done because the society is not yet ready for them. At such a time when the society in this country wants, if we are even just fighting over allowing a Catholic marriage to become polygamous, how are you going to say now people will go and a woman will go to get multiple marriages in a church? It will not be allowed, or in a mosque, or in a civil. So some things will not happen because the society is not ready for them. If it happens when we are all dead, good for those who will be alive. Thank you.
I hear you, Robert. Colleagues online, it is 21 minutes past 1, and we do not want you to suffer from ulcers for having held you longer on call. As Robert has clearly pointed out, and other speakers, as Ugandans, we need to preserve our cultural values and morals. Certain things we should leave them to those others who are pushing us into that direction. On behalf of my colleague, Philip, and the Uganda Law Society in general, I thank all the presenters, led by Senior Counsel, our teacher, past President, Dr. Diana Harriet Musoke, Senior Innocent Indiko, and my land brother, Robert Bogere Ali, for having spared your valuable time to come and educate us on this critical bill, that it is not only going to cause us a lot of headache, but also bring in more litigation which you would have avoided. Indeed, as you have all rightly guided, we need to rethink most of the provisions in the bill Robert suggests a total overhaul and the deletion of the bill, and we go back to 0. Senior council proposes changes in most of those ridiculous sections: Zomo marriage, marriages at the embassy, distribution of properties, name it. If we wanted to continue with this discussion, I'm very, very sure we can talk until the cows come home. Our colleagues who have injected in a lot of money, other presenters, Henry Kulova, Prima Kwagala, His Worship Olum, who was our CEO at the Uganda Law Society. Thank you so much for having created time to be with us. From our end, it's a good afternoon, and may God bless all of you. Philip, there you go.
Okay, thank you so much, Mr. McKay. I don't have much to add. I think you've re-echoed our thoughts and conveyed our gratitude to all the presenters and panelists. And to you all who have been listening, thank you for staying with us for all this time. And I want to say thank you to the ULS, and I wish you all a great day. I bring this panel discussion to a close. Thank you so much. Thank you so much.
Biru nedda.